need to have access and stuff like that. Because how did you? What did you remember this time? We to go to that conference, didn't have a file and we can't get the actual agency number. Really.
All right. I think everything is set up. Good morning again. We have, I think it's the Ms. Rios Day.
Yes.
We have a final plea calendar of exclusively her cases. So does that mean there'll be some pleas that we get halfway through and then they withdraw? No. We'll manage those. And then we have, is Mr. Turner here? I see his lawyer here.
Good morning.
Great. We'll talk about that issue with the ankle monitor as well. But let's do attendance first, Ms. Rios, with your clients. We have Mr. Moses, and I think I see him. Mr. Moses, are you at Washington State? Whoop, his camera just turned off. I think that's Mr. Moses on from the Department of Corrections. Was that your understanding?
Yes, Your Honor. And I sent an email because this case is a little bit more complicated and he also is hiring. I spoke with,
Well, we're going to wait till he's plugged back in and we'll sort that out. But that's where Mr. Moses is. Michael Mack. He's here.
Your Honor, I used the time to talk with him. I was not, I think his phone had been off because the number I had was not working. So I've not been able to go over discovery, relay offer, any of that stuff.
Okay, so you'll talk today?
Yes.
All right. And Deputy Gordon, have you sorted things out? Not yet. Okay. Preston Cobb. Good morning.
Before Your Honor got on the bench, I was talking to Mr. Cobb because I also was able to talk to him. I do not think this case is going to be resolved today, though.
Okay.
I still need to go over discovery and things with him. Also, there's some stuff in the evidence link that I'm not able to open. And the amount of time the state is offering, I don't believe we're going to be able to, and this is my first time even relaying the offer. So I would ask that his final plea rights be intact and then let him go to the trial counter. In the meantime, I'll talk to him. I have good numbers for him and his mom now.
Okay. Mr. Cobb, do you have a way to reach Ms. Rios? All right. And does she have a way to reach you? Okay. Ms. Smith, any issue with, so some of the folks on today's calendar will be on the May 7th calendar and some will be on the calendar at the end of May. Mr. Cobb is, I think, one of the people on the May 7th calendar. He is. Okay. Any issue with just keeping him on that calendar, but maintaining his final plea rights?
No problem with it.
Do you have any discovery concerns or there just may be a technical hiccup?
I think the device that was used to capture how fast the car was going, I tried to open it too and there was some issues. So
Okay.
work it out.
It's one of those, it's kind of proprietary software. Okay. And you'll figure out what the magic driver is to make it open and run. Okay. So Mr. Cobb, Ms. Rios is going to want to be in touch with you and meet with you soon so you can look at the discovery she has. She needs to get, figure out how to open some of the discovery she received. And I will see you next on May 7th. That's a Thursday, about a month from now, a little less than a month. You'll need to be here in person, 9 a.m. And that'll be the time when you and Ms. Rios tell me we've worked it out or we didn't, but we're ready to go to trial. And then that following Monday, I think we'll be in a position, that Monday to try the case. Okay? Any questions? Let me check one thing.
Oh, okay.
Did you get something in the mail telling you to be here today?
Yes, sir.
Good.
Yeah, okay, my address, last time, because you remember, they had no numbers on there.
Okay, so hopefully we got the right numbers in there. I'll check in just a sec. All right, so you're not supposed to drive until we work this out, but that's been true for a long time. You've been not driving?
Well, I got my license, but I didn't know I wasn't supposed to, they didn't let me know that I wasn't supposed to drive.
Okay, well, it's there in big bold letters on your bond order, no driving. Maybe that's been modified. Let me look.
I didn't know nothing about that.
Who's the they you're talking about?
Well, when I first got bonds and all that, when I first got a bond, cause I didn't get locked up for these cases until after a year. They didn't lock me up right after, cause I was in the hospital for 2 months, and all that. I was still healing and recovering and all that.
As a result of the accident? So you got injured in the accident as well? Okay. Got it. Oh, okay. So I do see. So this was in June of 23 that the accident happened. And then you're not arrested until August of 24. Okay. And then you got your bond. Your bond order says you're not supposed to drive. If you want to address that, Ms. Rios, you need to engage with Ms. Smith on that, because technically, not just technically, Mr. Cobb is violating his bond when he drives. And so I'm not saying you don't have a license. It's great that you have a license. It didn't say don't have a license or don't drive without a license.
I had got already up to something I couldn't get around like witnesses, but the lady, she didn't say nothing about, McGee, she just said it was.
Okay, I'm just reading what's in the bond order. It's there. It says no drugs, no weapons, no driving. 3 no's. No drugs, no weapons, no driving. That's the only reason why I checked. Often with the kind of charges you got, that's what a judge says is, hey, I'm gonna give you a bond, and I want you to get better if you were recovering and go to school or work, but you can't drive because of these allegations. Reckless driving, speeding, injury by vehicle. So I get why the judge said, till we get to the bottom of this, you should not be driving. I don't know how that didn't get to you. Like I said, it's printed right there. But Ms. Rios, I need you to work with Ms. Smith to see if the state's open to modifying the bond. But if not, you need to not drive now. You're hearing me say it. It's in your bond order. And then wait for Ms. Rios to talk with the prosecutor. And the prosecutor may agree to modify the bond, and then I'll remove that. I appreciate the fact that the incident was 3 years ago almost. This bond was almost 2 years ago, and really, someone could have. It took a long time for the case to get in. This has moved very slowly because it didn't get indicted for a year either. And so you may have been driving around, but there wasn't a lawyer to tell you, wait, that's your bond says don't do that. Ms. Rios hasn't had the case very long. But
Well, the thing is, I haven't been driving. I've been having my driver's license, but I just got a car.
okay,
So I haven't been.
well, that worked out well for you. But now you got license and car, but you've got a bond order that says don't drive. I'm going to ask Ms. Rios, and I'll put this on the calendar here, to have that discussion, and then shoot me an email. If there is no disagreement, I can modify the bond. We don't have to drag you back in here. But if there is a disagreement, we may need to have a hearing on it. But I'm just to reiterate, Mr. Cobb, until a judge, and I'd be the judge to do it, modifies your bond, a different judge, for good reason back then, but again, that was 2 years ago, said you shouldn't drive. Okay? Yes, ma'am.
I'm sorry, I'm his mom, I just want to, speak on his behalf because of course he has a STI injury. Is there any way that it can be modified for him to work because he really only drives to go to work?
So I'm open to that, and that may be the kind of conversation the prosecutor wants to have with Ms. Rios. Well, okay, could we limit it? And so he's only allowed to drive. Like sometimes we actually issue provisional licenses where if you were to get pulled over, your license would say all that Mr. Cobb can do is drive from home to work. And so if he's found up in Dunwoody, he's in trouble because work is here and home is there. And that may be the kind of thing that Ms. Smith, on behalf of the state and consulting with the victim's family, might think, hey, you know what, let's let them get to work or school, but no joyriding. That doesn't strike me as unreasonable, but I'm new to the case too. This case, once it got indicted, it has moved quickly. It moved slowly until then, but there haven't been fights between the sides. We didn't have any motions to suppress, not that kind of case. So here we are going to be in trial or resolve it in about a month. But in that month between now and then, unless the bond order is modified, you or Uber or someone else would need to get your son to work and back.
Yeah, he was doing Uber anyway, so.
Okay.
that's what he was doing.
And that's fine, because that's not driving. But if he now has a license and keys to a car, I could see why that could be cheaper, to do. But Ms. Rios needs to confer with Ms. Smith, and then, she'll certainly let you know what's decided. All right, Ms. Rios, anything else with Mr. Cobb's case?
No, if he could hang around for a little while, because I might be able to talk to him and show him a couple of things.
Great. So, Mr. Cobb, you and I are done chatting for today, but please don't leave. Once I get through calling this calendar, Ms. Rios wants to spend a little time with you, okay? All right. Tanya Collier. Hi, Ms. Collier.
We are ready on a negotiated plea, Your Honor.
All right, we will do that this morning.
That's my case.
Okay. Hi, Ms. Willingham. Did you get to wherever you had to be yesterday?
I do.
Great. Chrisdell Gatlin. Oh, I'm sorry, we will handle your case in a little bit, Ms. Collier. Good morning, Mr. Gatlin.
We are also ready on a negotiated plea for Mr. Gatlin too.
Okay, and Deputy Gordon, you've confirmed your information? All right.
That is also my case, Judge.
All right. Larry Walker.
Good morning,
Good morning, Mr. Walker.
Your Honor, I would be requesting that we go forward to the trial calendar and keep his final plea rights open. There's some new information I just got recently, and I still need to talk to Ms. Williams about the case, because I believe she said the offer has changed, or.
Well, we never extended an official
yeah.
offer, so I just want to give Ms. Rios a heads up that today would be a good day to discuss that while everybody's here.
Yes, let's talk. And when you say you just recently received information from Mr. Walker or that side of things, or from the state?
Well, I don't have an offer from the state yet, but I also was getting some information from Mr. Walker. They just sent me an email about some medical records and some information about the child. So I'm not sure if it'll be able to get resolved today.
Okay.
Yeah.
Why don't you three talk and let me know. And then again, there's three options. One is it's resolved. Another is it's not resolved, but the final plea, which is what was supposed to happen today, we do that. And he says, no, thank you. Or that third option, which seems to be what you're advocating for, you share with me a little bit more why I ought to preserve the final plea rights, because one could be because you just got the offer. Another could be you just got this information. I just need to understand why you only now got the information, but we'll work through that. All right. And then the final position is Ms. McGee Russell. She is here.
I have not had an opportunity to talk with her. So we will talk. I know the state has a recommendation that would be a behavioral health court recommendation. So I just need to discuss that with her.
Is this a Ms. Willingham case or a Ms. Smith case? Okay. It's always hard to test. It's got family violence battery in there. You guys divide things up in a peculiar way. So Ms. Smith got you an offer. You had a little difficulty tracking down Ms. McGee Russell.
Yes, sir.
Okay. So why don't you talk with her and don't excuse anyone until I get a chance to talk.
Yes, Your Honor.
Does that work?
Yes.
right.
I want to just how did you want it handled today? Because I have 2 pleas. The misdemeanor pleas are fully ready to go. I already went over their rights with him. So I don't know if you would rather just get those out the way and then take a break and then let me talk to everyone.
That's fine with me. We can do that. So we got to figure out what's going on with Mr. Moses. I don't want to keep Department of Corrections on, so we're going to do that in a second. And then to recap, you've got the Collier plea and the Gatlin plea.
Yes, Your Honor.
Okay, and you said those are ready to go. All right, so,
If it helps, I actually text Attorney King while we were kind of working through the calendar. He confirmed that he is gonna be representing Mr. Moses and that he's gonna get a entry filed today.
okay, and who is the lawyer? Kamani King, okay, all right. Well, that's good to know. Let's get,
Yana, do I have time to go to 8A for a quick bond hearing and come back?
Sure, we'll do we could do it either way. I was gonna turn to you after this, but if you want to go do the bond hearing, we can knock out one of the pleas, and when you get back, you and Mr. Turner and Ms. Smith and I can talk.
I shouldn't be long at all.
Okay, I'll be here, so that's great.
Thank
So Mr. Turner, sit tight. Your lawyer will be back. He is a man of many courtrooms, so he'll return.
Thank you, Judge.
Mr. Washington, I'm sorry, Mr. Moses, can you hear us? So you're on mute. We need you or someone from Washington State to unmute there. There we go. Great. Good morning, Mr. Moses.
How are you today?
I'm okay. How are you?
Oh man, hey, I'm here.
You are here. Tell me why you're there. Are you under sentence? Did you have a revocation? Why are you in the state system?
Probation violation, sir.
And how long is your revocation?
They took a year, and it's from. I was arrested in July, but I was trying to figure out whether or not they was going to give me my county time. I'm not sure whether or not they're going to give me my county time, but it was for a year from July to July. I've been locked up. It'll be a year in July, but I got sentenced for my revocation in August.
Okay, so you may get out in July. That would be maybe the latest?
Well, I got a TPD for this month coming up.
Great.
Which is May.
Okay.
So, and I'll be done did approximately around 10 months by then. So,
okay.
Whatever the Lord holds in store for me.
All right. And you got a case with me, and it sounds like you are wanting to bring on board Mr. King as a lawyer?
Yes, sir. I've spoke with Mr. King, and he has assured me that he would be connecting with you guys on this matter. I've spoke with with Mrs. The public defender.
Ms. Rios, yep.
Spoke with Ms. Rios, and she's in compliance with everything. Would like to resolve this matter as soon as possible, Your Honor.
Okay, but you'll be resolving it with Mr. King as your lawyer, not Ms. Rios.
Correct, sir.
Okay. We will let Mr. King know that he is coming on mid-process. We're not going to slow your case down. You have...
Right now, excuse me for cutting you off, Your Honor.
Pardon me?
As of right now, what do you guys have in mind as far as the case? Because if you guys got something in mind that we can resolve, then we may not need Mr. King to come in.
Got it. So I don't have anything in mind. All I know is you're charged with having a stolen Porsche and using someone else's ID. I would need to learn from your lawyer more about the case, learn from the prosecutor more about the case. So I have in mind making sure your case moves along quickly. That's it. My goal is to make sure you don't get stuck, your case doesn't get stuck. Your case is on a trial calendar that we call at the end of May. You may still be there, you may be out. Of course, we need to know where you're going to be when you get out. Although you may still be there. That doesn't mean we can't handle the plea with you at Washington State. But a lawyer who represents you, and it sounds like that's going to be Mr. King, needs to talk with the prosecutor, Ms. Smith, who's here in court, about how to work this out. Today was a day we were going to do that, but that would be with Ms. Rios. And what Ms. Rios learned was that she was being replaced by Mr. King. And so she understandably stepped back and said, well, I shouldn't negotiate on behalf of Mr. Moses because he is bringing Mr. King in. And Mr. King can then have that conversation. He just needs to do it in the coming weeks so that by the end of May, when your case is called to trial, if it's not going to be a trial, he's in a position to say, hey, we've worked something out. Mr. Moses is interested in taking this plea, and that's what we do.
I can offer a little bit of context. So
Okay, Ms. Rios.
So when I was talking to Mr. Moses, it was clear that he believed he already pled to the same facts of this case in a different county. Mr. King handled that case. So I called Mr. King and he says, yeah, I remember, I believe he already pled it. It was too much the same color car, and so he just needs to find the information of when he took the plea with him, because I was asking him for that because he would be better to get that for me and then give it to Ms. Smith. But he was like, well, he might as well handle the case since he was the one who handled the first case. And this seems to be like the same thing.
Well, and you mentioned that. And so I looked it up, and in looking at the affidavit that's filled out, the claim is that around 4:00 in October 2024, the police pulled the white Porsche over on Metropolitan Parkway. That is not, if it was Moreland, like, all right, you know what, maybe if he turned left, it was a DeKalb case, but he's right smack in Fulton County with this. So I don't understand how this would be the same situation, or put differently, how DeKalb would think they had jurisdiction over a stolen car allegation where that possession was on Metropolitan Parkway.
I'm not sure. When I called Mr. King, he believed that they're similar. So, because I was asking him to look up the information, I was a little confused. But either way, when I had him on the phone, and I also had Mr. King on three-way, and then they started talking, and they were like, "Well, I might as well take your case." So
okay, got it. Well, what I'm going to do is let Mr. King get involved. And he may well be able to show Ms. Smith how Melissa, the stripper's Porsche on Metropolitan Parkway is related to something in DeKalb County, and we'll figure that out. But in the meantime, Mr. Moses, you are earning good time on your revocation, and Mr. King will get to the bottom of, is this the same case or a different case? If it's a different case, Mr. King, can talk with the prosecutor to see if there's a way to work it out short of trial, and he'll be in touch with you, okay?
Okay, sir, thank you.
Any questions about any of that?
No, sir, I'm clear.
Okay. Ms. Smith, any objection to leaving the final plea rights in place, given this transition in representation?
No, Judge, I just wanted to also say there is an offering. You have discovery. I talked to Mr. King. I'm just waiting for him and waiting for him to do that entry, and we'll send it over to him.
Great. Okay. I'm assuming discovery is not particularly voluminous in this case? Great. All right. Have you done any research into, there's a DeKalb case, same car, similar car, or you're just hearing, hey, this may be something that was somehow resolved in another county?
Yeah, the latter.
Okay.
Looking into it.
All right. All right, Mr. Moses, we will take it from here. Thank you to Department of Corrections for getting you on. You have a good rest of your Friday.
Thank you, sir, thank you.
All right, Ms. Rios, should we take your pleas now?
Yes, let's do Ms. Collier.
All right, Ms. Collier, if you'll come on up to the podium, please.
Sorry, Judge. That's fine. I'll make it work.
Let me know when you're ready.
Okay.
1 second. Now my turn to.
Yes.
Okay. All right. Good morning, Ms. Rivers.
Good morning.
You ready to take a plea down?
Yes, I am ready.
Great. This is 25 SC 006-718, State versus Ms. Collier. Ms. Collier is here with Ms. Rios as her lawyer. Ms. Willingham is here for the state. Ms. Collier, to go through a guilty plea, you have to be sworn in. Ms. Willingham will do that. Once you're under oath, you're going to need to answer some questions about your rights and about your case. I need you to do that, but I also need you to let Ms. Rios or me know if you have any questions. If we start talking about something that doesn't make sense, or it's not going the way you thought it was, call a timeout and say, wait, could you explain this? I need to make sure you tell me if you're confused by something. Will you do that?
Yes.
Yes, okay. And when you're answering questions, make sure you answer out loud. The court reporter can take down only the spoken word. I know you can't see her. She's invisible.
Oh.
She's virtual, so she can see you.
Okay.
She's working from the home office today, but she creates a record based on what's spoken. So you're welcome to nod your head or shake your head, but words need to accompany that.
Okay.
All right? Ms. Willingham.
Good morning. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Tanya Caprice Collier.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medication.
And what kind of medication is that?
I take 8 different kinds for hypertension and large heart and arthritis
Does any of
and
them,
mental.
I'm sorry, repeat the last thing and then I'm gonna ask you a question. That last part.
You said you take it for large heart, and then you
And
said,
large heart.
and,
Severe hypertension,
and,
arthritis, and depression.
And does any of that medication alter your ability to understand what's happening today?
No,
Okay. How old are you and how far have you gone in school?
I'm 64. I graduated from high school.
And are you able to read, write, and understand the English language?
Yes.
Ms. Rios, have you had the opportunity to review the indictment in this case with your client?
Yes,
Do you waive formal reading of the indictment?
yes,
Ms. Collier, do you understand that although you are charged with aggravated assault, possession of a firearm or knife during the commission of a felony, the state will be null processing count 2, which is the possession of a firearm during the commission of a felony, and we will be reducing count 1, aggravated assault, to disorderly conduct under OCGA 16-11-39, and you would be entering a guilty plea to that count for 12 months probation, and you would be required to have no violent contact with the victim, complete family violence intervention program, and complete 60 hours of community service and have no weapons?
No, I'm gonna say guilty.
well, she wants to make sure you understand that's going to be the negotiated
Oh,
resolution.
yes.
That's not a surprise to you, 12 months probation, all those conditions. You understand those are what you've agreed to do.
Yes.
Okay.
Okay, and Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
And do you need any more time to discuss this case with your attorney?
No.
Ms. Rios, have you had the opportunity to advise your client of the minimum and maximum sentence of disorderly conduct?
Yes.
And Ms. Collier, you understand that minimum sentence is 1 day and the maximum is 12 months in custody? The possibility.
Yes.
Okay. Do you understand that this is a negotiated plea of guilty, which means the state and your attorney will make a sentence recommendation as just explained to you just a moment ago? But the court does not have to accept that recommendation. The court can sentence you to the maximum sentence as we just discussed, which is a 12 months in custody sentence.
Yes.
But because today is your final plea, you have the right to, if you do not agree with the court sentence, you can withdraw your guilty plea today. Do you understand that?
Yes.
And are you on probation or parole for anything, anywhere?
No.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Guilty on the offer.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Are you still asking the court to accept your plea as a guilty under Alford?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA section 5-6-35.
Yes.
And I'm sorry, I'm going to go back. Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, and the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved by the state beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Okay, and Your Honor, if this case were to proceed to trial, the state would expect to show that on October 23rd, 2024, East Point police officers were dispatched to 2360 Dello Drive, apartment 15 in Fulton County for a domestic dispute between Ms. Collier and her live-in boyfriend, Mr. Thomas. Mr. Thomas told officers that during the argument in their kitchen, Ms. Collier became angry, began throwing items, and then picked up a kitchen knife and waved it towards him while stating that someone needed to call the police or she would kill him. Mr. Thomas stated he was afraid for his safety and she made those threats while holding the knife. Mr. Thomas's grandson, KD, witnessed the incident. He reported that he saw Ms. Collier retrieve a knife from the drying rack beside the kitchen sink, hold it with the blade pointed toward Mr. Thomas, and pace back and forth while repeating that she would kill him if police were not called. Both witnesses independently confirmed that Ms. Collier brandished the knife and made verbal threats to kill Mr. Thomas. Your Honor, I have had an opportunity to speak with Mr. Thomas very briefly. Actually, we attempted to call Mr. Thomas initially, and Mr. Thomas called us back while with Ms. Collier. They actually contacted my investigator back. And during that call, we learned that the couple had been together for quite some time. Mr. Thomas states that although the knife was pulled out, it wasn't really pointed at him. He stated that it was more so kind of like down to the side. Although we recognize that we could still use his original statement to law enforcement based on the age of this case as well. The state determined that as the parties have not had any other issues since then, that this was a fair and reasonable resolution. And I believe Mr. Thomas is present in court today.
Hello, Mr. Thomas.
Hello, how are you?
I'm all right. You and Mrs. Collier been talking for a while?
19 years.
19 years.
Been together 19 years.
Why don't you make it official, Mr. Thomas?
Well, I'm 70 years old, so.
There you go.
I'm down here now.
Are you okay having Miss Collier around?
Of course.
Sometimes it gets a little bumpy. All right. One of the conditions that the state has asked for is no violent contact. So the two of you can still be together, but if you get into arguments, Ms. Collier needs to walk away and not throw something or say something or wave something around. And you need to feel free to reach out for help if something escalates in that way. Do you work?
No, I'm retired.
You're retired. What'd you used to do? All right. Does Ms. Collier work?
No.
You guys get retirement benefits or? Excellent. Okay. 19 years. I appreciate you being here. Anything else?
Nothing further, Your Honor.
All right. Criminal history information.
Can she? I don't know. Can she?
I'm not sure. Belt it out. Thank you.
You got 4 cycles, 2012 ag assault, possession of a knife during the commission. I talked to the state, it's dismissed.
It was
It
an
was-
immunity motion,
Oh.
and she succeeded on that.
Got it. It's interesting. It's similar charges. Who was the person you were mixed up with in that case from 2012? Mr. Thomas. Huh. All right. So this wasn't the first time.
Quite a few years ago.
Yeah. Okay. All right. That's it. Thank you. Okay. Maybe you both should go to family violence intervention, but it's your case, not Mr. Thomas's. All right, Ms. Rios.
Yes, Your Honor. Ms. Collier is 64 years old. She does have a lot of stuff going on with her health that she's struggling with and her mental health, and that's why she's on disability for those things. She has 5 grown children, and she currently takes care of her father who had a stroke. I just ask that you go along with the negotiated plea and waive the fees.
All right. Ms. Collier, your father, I'm sorry about the stroke.
Yes.
When you're taking care of him, is he living with you or?
Yes, he lives with me.
Okay. And do you and Mr. Thomas live in the same place?
Yes,
So the three of you and Mr. Thomas and your father are all in the same place?
yes.
Your 5 kids are all grown? Are they local so they can help out or are they far away?
They come and see, they come and they most every day.
Okay.
They call me 3 or 4 times a day.
Good. So
But
they
they all
take time.
done graduate from college.
Good.
I got one going now for city, what is it, Councilman, District 62, my son.
Fantastic.
Yes,
Well, good kids.
yeah.
And they're there to take care of you if you need it.
Oh, yes.
Okay.
But, they get someone too, but they work a lot.
Yep. Okay. Do you have any questions about what we discussed?
No,
No? Okay. You and Mr. Thomas need to, even after 19 years, come up with ways when you're having a disagreement, and you're going to have disagreements, to do it where it's words and not more than that. And that may mean people need to take a walk or go
Yes.
for a ride or just go to the other end of the house.
Yes.
But if something like this happens again, we've got the case from 2012, and I appreciate it was dismissed. There was an immunity motion, but that's still the two of you
Yes.
getting into it.
Yeah.
We got this, and that's not bad. That's 12 years apart. That's 12 years where the police didn't have to
And the
show
last
up.
time,
Pardon me?
and this is the last time.
Okay, well, good. You guys do your best to try to talk it through. If I had been there on October 23rd of 2024 when this happened, would I have seen that people were drinking? Did that contribute to it at all?
Probably so.
Okay. Well, here's what I'm going to do, Ms. Collier. First, I find there's a factual basis for your plea. I know it's an offered plea. You're saying, hey, it didn't happen quite like what the prosecutor's saying, but you've decided it's in your best interest to take the plea.
Yes.
I find that the state could still probably prove this up, given what was said at the time, especially the grandson saying, I saw her with a knife, it was pretty scary. That might not go so well in front of a jury for you, but you're resolving this. So I'm going to accept your plea. I also find that your plea is knowing, meaning you've understood what we've talked about.
Yes.
And voluntary, no one's forcing you to enter the plea. You agree with that?
Yes.
Okay. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And Ms. Collier, can we sign your name to the indictment indicating your plea to the misdemeanor?
Yes.
We'll do that. I'm going to follow the recommendation. I'm going to add one thing, but it's going to be 12 months probation. Special condition number 1 is no violent contact with Mr.
Yes.
Thomas. You can hug on him all you want, but you can't hit him with a rolling pin or wave a knife at him.
Yes.
You're going to need to complete the family violence intervention program, and that you're going to need to enroll in within the first 2 months. So you got 2 months to get started with that program. That's not just one class, it's actually a series of classes, and you may want to drag him along to the classes.
He will.
But you're going to need to provide proof of enrollment within the first 2 months of probation. I don't want you waiting until month 11,
Yes.
because then you won't finish it. You also need to do 60 hours of community service, and you should talk with probation about where to do it. I don't want it to be something, given your health, where you're not going to be breaking rocks or picking up heavy things.
Yes.
But it could be as simple as you're working in a soup kitchen, helping serve food for folks who need the food, or wherever you can do volunteer work where they can document it. And you need to do that within the first 6 months of your probation. So again, you're not waiting until the end, but you got 6 months to knock out the 60 hours. And the thing I'm adding is that I'm going to direct that you submit to a drug and alcohol abuse evaluation.
Yes.
And that's just going to be a medical professional who talks to you about how you live your life and what you put in you. And if that person recommends treatment, that treatment is going to be part of your probation, whether that's going to meetings or seeing a doctor or whatnot. But if part of making you healthier would be addressing, hey, maybe you drink too much, you drink too little, whatever it is, let's have someone who knows about that talk with you about it and figure out, is there some work that could be done there?
Yes.
I will waive your probation supervision fees, given that you are on government assistance. No point in just moving it from one pocket to another. You will need to report to probation when they reach out to you. That form that Ms. Rios and you are going to fill out in a minute, it's going to have all your contact information. They're going to call you or email you. I don't know which way they do it, but they reach out to you and they'll let you know how to connect with them. Don't miss that first meeting, because they reach out to me saying, we can't find this lady and we got to do a warrant and all those things. Okay. Ms. Willingham, anything else in this case?
No, Your Honor.
Mr. Thomas, this is your chance. Any other conditions of probation? You want to make sure you get pot roast once a week?
Yeah.
Yeah, can't do that, sorry. Yeah, Ms. Rios, anything else on behalf of Ms. Collier?
No, Your Honor, thank you.
All right, Ms. Collier, good luck with things and take care of yourself.
Thank you. Well,
Can we do Mr. Gatlin?
We can. I was gonna say, you were flipping through all these pages and going, I don't remember you having all the fancy that you spill your coffee on it and it doesn't. Yes.
Stomach hurting.
Let me know. You're handling Mr. Gatlin also? Yes.
1 second.
Okay, let me know. Do you need a different binder or you're gonna work with that binder? All right.
I think I got it.
Good morning, Judge.
Hello, Ms. Simpson. How are you?
I'm good. Could you please check your chat before you begin?
Yes, ma'am. All right. Good to go? Okay, Ms. Rivers, we're going to get on the record in State versus Gatlin. It's 25 SC 007135. Mr. Gatlin is here with Ms. Rios. Ms. Willingham is representing the state. Mr. Gatlin, you ready to go forward?
Yes, sir.
Okay. You just watched the plea, so you know how it's going to flow. Ms. Willingham is going to put you under oath, ask you a bunch of questions. You need to answer those. You need to let me and or Ms. Rios know if you have any questions.
Yes,
Okay? Let's go.
Please raise your right hand. Do you swear or affirm that the testimony you give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Chris Dale Gatlin.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
30 and GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Ms. Rios, do you waive the formal reading of the indictment in this case?
Yes.
And Mr. Gatlin, do you understand that you are currently charged with aggravated assault? However, the state has agreed to reduce this to battery, family violence under. Ms. Nelson, I will get you the code section. Wait,
You
it's
do
not.
your thing. I can do. If
Thank
you
you.
found it, go ahead.
I thought it was on here.
All
It's
right,
not.
I'll get it.
Is that your understanding?
Yes, ma'am.
Okay. And have you had an opportunity to review or discuss with your attorney the rights you are giving up by entering a plea of guilty today?
Yes, ma'am.
And have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
Have you been arrested on these charges?
Yes. No.
Yes.
I don't know. Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges? And has your attorney advised you of the minimum and maximum sentence for the charge you are pleading guilty to?
Yes, ma'am.
And just for the record, battery family violence has a minimum of 1 day and a maximum of 12 months in custody. And do you understand that by entering a guilty plea to a family violence conviction, if you are found in possession of a firearm, you could be charged on the federal level?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other. In this case, the state and defense have agreed to 12 months probation. You would be required to complete family violence intervention program and complete 40 hours of community service, have no contact with the victim in this case. And it is my understanding that your attorney will be asking for early termination. The state has agreed to defer to the court as to that.
Yes, ma'am.
Is that your understanding?
Yes, ma'am.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Are you currently on probation or parole for anything, anywhere?
No, ma'am.
Are you a United States citizen?
Yes.
Do you understand that you have the right to plead either guilty or not guilty?
Yes, ma'am.
Do you understand that if you plead not guilty, this matter could proceed to trial either by bench or by jury?
Yes, ma'am.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses, assertions of self-defense, and assertions of immunity from prosecution?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Guilty under Alfred.
Guilty under Alfred.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Are you still asking the court to accept your plea as guilty under Alfred?
Yes.
As to indictment number 25SC007135, how do you plead?
Guilty under Alfred. Guilty under Alfred.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA Section 5-6-35. Do you understand that the appeal that we have just discussed must be filed by your attorney unless you are representing yourself?
Yes.
Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
And Your Honor, if this case were to proceed to trial, I'm sorry, I have to switch back to that screen. The state would expect to show that on May 27th, 2024, Hannah Merritt filed a police report alleging her boyfriend, Mr. Gatlin, had assaulted her the day prior in their apartment at 250 Piedmont Avenue Northeast, apartment 1406 in Fulton County. According to Merritt, Gatlin became upset when Merritt would not engage in sexual intercourse with Gatlin and another unnamed female. Merritt refused to have sex, so Gatlin became upset and punched Merritt in the face and threw her to the ground. Gatlin then put both of his hands around Merritt's neck and choked her until she almost passed out. Merritt reports that Gatlin also dragged her outside of their apartment while she was naked. Merritt was not planning to get law enforcement involved because she did not want to see Gatlin in trouble. However, Merritt's friend encouraged her to file a police report the next day. Your Honor, I've had an opportunity to speak with Ms. Merritt. One of the state's concerns in this case was that in speaking with defense counsel, they mentioned that the defendant stated that the other person actually got into an altercation with Ms. Merritt. When I spoke with Ms. Merritt, she does not disagree that there was an altercation between her and the other woman. She states that that altercation actually occurred earlier in the day, but it did put us in a position of where that leaves us with a jury believing who actually caused Ms. Merritt's injuries. Because this—
Not that she wouldn't have been frustrated with Mr. Gatlin, but that if she said, look, I have a black eye, did it come from this woman he brings home to say, what do you think? Versus did it come from him?
Yes.
Okay.
Because she did acknowledge there was a physical altercation with her as well. And then based on the rest of the facts and circumstances, it does create a bit of concern for the state in moving forward and how a jury would see it as a whole. But in speaking with her, she was comfortable so long as the defendant accepted responsibility. She just did not want us to dismiss it. And I told her that we would see what would happen today, and then we'd have a further discussion if we needed to prepare for trial.
Okay.
But she is aware of today's plea, and she is comfortable with it being a misdemeanor based on some of the state's concerns about the case and the other person being in the home.
Okay. And Ms. Merritt wants no contact, not a no violent contact, but I'm done with this guy. He needs to leave me alone.
That is correct.
Okay. I understand that. Thank you. Criminal history, if you don't mind approaching the microphone again. Morning, Sarge.
5 cycles, 2017 failure to appear, no felony convictions.
All right. Thank you. Ms. Rios.
Yes, Your Honor. Mr. Gatlin is 30 years old. He has lived in the Georgia area for over 10 years. He's a tattoo artist and has been doing that for 10 plus years. He has 2 children, 2 boys aged 3 and 4. And that's why the plea is under Alfred, is because he's maintaining that the other woman and they got into a fight and he never touched her. She was, of course, angry at the situation, and that's why she's saying that it was him and not her. And so that's why we're asking for the plea, for you to accept the plea as negotiated.
Okay. Mr. Gatlin, any questions about anything we've been discussing?
No, sir.
Okay. You're rethinking that plan in the future?
Yeah.
Yeah, that's going to create some tension.
So I don't even know why I'm pleading this, but yeah, I didn't do all that stuff.
Okay. Well, but it's an offered plea. So you're not saying it went down exactly as the state is saying, but you are saying, I want to work this case out today along the lines of what my lawyer was able to negotiate. Is that a fair summary?
Yes, sir.
Okay. Well, Mr. Gatlin, I find there's a factual basis for the plea. If Ms. Merritt came in and told a jury what she supposedly told the officers, a jury could end up believing her, might not. I understand why the state had concerns because of the third leg of the stool that would be complicated for the state. But I think there's enough evidence out there that it makes sense that you're pleading. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter the plea. Do you agree with that?
Yes, sir.
All right.
I did forget one thing. As the state mentioned, I was going to ask for termination after the family violence course.
Okay, got it. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And Mr. Gatlin, can we electronically sign your name to the indictment reduced to a misdemeanor as an offered plea?
Yes, sir.
We'll do that. Mr. Gatlin, I will, for the most part, follow, I guess it's not quite fully negotiated. I'll follow the negotiated part. So I'm sentencing you to 12 months probation. The number one condition of probation is no contact with Ms. Merritt. You don't call her, you don't text her, you don't post something that you know she's likely going to come across that involves her. You can be active in social media as you try to grow your business, but nothing about her. She's moved on and she needs to be able to do whatever she's doing with you not involved. I don't know if you guys still have contact. That's not meant to be a trap for you. If for some reason she reaches out to you, don't respond.
Yes, sir.
Because you responding to that is the kind of thing she could run to the DA's office and say, look, he texted me. Even though your text was like, hey, you need to leave me alone. If she's reaching out to you, you just let Ms. Rios know that. She'll let the prosecutor know. And they can say, we need to change the conditions of probation. If you, Ms. Merritt, want to reach out to Mr. Gatlin, then you ask for no contact. I'm assuming she's not going to reach out to you. More importantly, you don't reach out to her.
No, sir.
All right? You'll need to complete the family violence intervention program. You need to enroll in that within the first 2 months of probation. It's more than one class, and it takes a little while, so I don't want you waiting until the end. And you'll need to complete 40 hours of community service. Those you'll need to complete in the first 6 months of your probation. And if Ms. Rios, you want to reach out to me after Mr. Gatlin has completed the family violence intervention program and there's proof that he completed it, then I'm happy to get a report from probation to see how he has been doing. And then we could discuss an early termination. But for now, it's going to be the full 12 months. If you take care of the things you need to and get a good report from probation, then I will take under advisement early termination. Okay? Two more things. One, you need to fill out a sheet that has all your contact information. That's how probation is going to get in touch with you.
Okay.
And they'll give you directions on where to report. Mostly it'll just probably be telephone reporting, but you may need to go there in person once. That's how they reach you. Don't miss that first appointment.
Yes, sir.
Number two, there's an active warrant for you. So you actually have to go into custody now. You have a bench warrant at a state court for family violence battery. We verified the warrant and I can't make another judge's warrant go away, but Judge Edie from state court signed a bench warrant for you.
For where? When? What? Oh.
I'll pull up what I can pull up, but you gotta fill out that form. And then one of Ms. Rios's colleagues will step in to figure out more about that.
I figure out who your attorney is and send him an email.
So,
Because he has no control.
It was issued in August of last year. So what that says to me is that you were supposed to be in front of Judge Edie in August of last year and you weren't there. But I'm not the one to say, I was there or I couldn't be there, I was somewhere else. I'm just letting you know some context for it.
oh man.
I'm gonna email my colleagues to make sure you're not forgotten this stuff.
And I can't get out today.
I don't know how state court works, of how fast that
wow.
goes, but I will reach out to them and let them know that you're there so we can, no one forgets about you. I'll send an email today. Did you know you had a case?
No, didn't know nothing. Then my girlfriend is out there. You could tell her.
That was, okay. Who's your girlfriend?
She's outside, on the bench. And Judge, you said that was when?
I'm printing it out so you can have it. But Judge Edie signed it on August 12th of last year. And it sounds like you were supposed to be in his courtroom on August 11th. Because the warrant he signed said that Mr. Gatlin failed to appear. The state asked for a bench warrant and he signed it. So I'll make sure the deputies give that to you. So you've got that as a reference when you want to talk to your lawyer, say, this is why you're in custody.
But I just had court, here. And when if I had a warrant, I would have went to jail the last time I was just here, right?
We may not have known about it, but I'll make sure they get it.
Yes.
Thank you. Yeah, oh, just so, I mean, any reason he shouldn't have it, that's the bench warrant, just so he can know what the situation is. All right, Ms. Rios, I know you've got some people to talk to. If I turn to Mr. Patterson and his client, is this a good time for you to talk with your clients?
Yes, it is, Your Honor.
Let's do that then. So Mr. Turner, come on up to the podium, please, with Mr. Patterson.
Good morning, Judge. Good to see you.
Good morning. Good to see you.
Thank you for allowing me to go to that bond hearing.
Hey, we took care of business and you guys are here still this morning. So we are on schedule. So we'll start informally with this. The concern, Mr. Turner, that brings us all together is that you've got a bond with some real serious charges. And it's a big bond. You got an ankle monitor, and you told me, your lawyer told me, we're going to comply with all the conditions. And I got a report that a couple weeks ago, you were in places you weren't supposed to be. And you were in Union City, and you're supposed to stay out of Fulton County, with a few exceptions. Obviously, you're in Fulton County right now, and that's okay. Visiting your lawyer is okay. If your arm got busted and you had to go to Grady, not an issue. But hey, I'm gonna kick it with some friends on Jonesboro Road, not okay. So share with me what was going on.
Absolutely, Your Honor. My client, fortunately, he works for Uber. And at the time on March 20th, at the time between 1:54 and 2:23 p.m., he was working for Uber Eats and picked up, Instacart. He picked up 3 orders at Kroger, and that was the location on Jonesboro Road. And that's the reason why I guess he apparently didn't realize that was Fulton County, but he was actually working for Instacart. And it shows he picked up 3 orders on Jonesboro Road in Union City at that particular time during that short period of time.
Okay. Got it. Yep. I guess that's a mall there.
That is
it
correct.
Pulls up a UPS store and a Kroger. So I guess you just need to be careful about, it's going to make being an Instacart guy complicated. But certainly if it is Union City, East Point, South Fulton, those are all in Fulton County. Where do you stay?
Hampton, Georgia.
Okay, so you are in Clayton County?
Yes, sir.
Got it. Basically, if you are going past the airport, meaning north of the airport, you're getting into Fulton. The airport itself is in Clayton County. Now, if your line of work means that you need to be in Fulton County as an Instacart guy, you need to talk with Mr. Patterson, and he can talk with Ms. Smith, the prosecutor. And it may be that the state is comfortable amending the bond conditions to say, as long as it's between 8 a.m. and 8 p.m. and it's for work, that kind of thing, maybe they'd be okay with that. But the judge who issued the bond said you got to be out of Fulton County, except for these few emergencies, not work, but lawyer, court, and going to Grady. This isn't that. So you either need to not do Instacart, kind of inside the perimeter, although there's some of Fulton County that's outside the perimeter, or you and Mr. Patterson need to talk and come up with a proposal that he would make to the prosecutor saying, how about not on weekends and only during daylight hours, 7 a.m., 7 p.m., it's okay if Mr. Turner's in Fulton County. And the ankle monitoring company, it's all an algorithm. And so if the state says that's not an issue, then I'd modify the bond and say, as long as it's between 7 a.m. and 7 p.m., it's okay if the monitor hits in Fulton County. But if you're there at 3 a.m. on Jonesboro, we have a different situation. So
I will certainly get with the state on that, Judge.
Between now and then, you can't do it. So if you get that Instacart call saying, go to the Kroger in Union City, in Fairburn, in East Point, those are College Park, that's all Fulton County. Don't go there, okay? I know you're not doing this stuff intentionally, but I can understand why the state would be concerned and why the person who's alleged to be the victim in this case would be concerned that you're showing up in Fulton County. The reason to keep you out was to keep the person who's named as the victim in this case feeling a little more peaceful about the fact that you have a bond at all, because that person didn't want you to have a bond. But the judge decided, given your background and representations your lawyer made, that it was safe-ish to risk giving you a bond. You need to not mess it up by doing something like this again, okay? Any questions? I don't want you to leave here saying, I didn't understand what the judge was saying, I'm confused.
In other words, you need to check your app to make sure you're not going to Fulton County until I get with the prosecutor to try to get it amended.
Okay.
Okay?
All right, you're smiling, that tells me maybe,
No, I had a question.
what's your question?
So, that's kind of my way of making money. Like, our side don't really have too many orders going on, so it'll be on that side.
Yep. So that's a reason for Mr. Patterson to start lobbying on your behalf to say, hey, is it okay if during certain hours, Mr. Turner is in Fulton County because it's for work? And it doesn't make a whole lot of sense to put you on bond and then say you cannot work. Just sitting at home isn't a productive use of your time. But if the state ends up saying no, it means you gotta find a different gig, that you can't do Instacart that brings you into Fulton County. There are lots of jobs out there. This is one of them, and it works for you. And it'd be ideal if you could keep it, but you have some constraints. Yes, sir.
Before you trying to follow the real, this first original bond was issued by the second judge that stated that he could go to work in school in Fulton County. And I thought that would transfer over to the modified bond, but that was the conditions before, so that's the reason why I encouraged him to work and he couldn't find a regular job, so I encouraged him to do something to get some money to pay for his ankle monitor, which it's been modified for the state because it was really supposed to be for the state in the first place. But the original bond stated that because when he was picked up in school in Fulton County. And at that time, the lawyer that was there representing him stated that he needed to go to school. So that's the reason why he allowed Fulton County work in school in Fulton County.
Apparently that bond was modified maybe at a bond hearing or something.
So I'm looking, I would have been the one who modified it at your request because having to pay for the ankle monitor was breaking the bank.
Correct.
Oh, I remember now. So it was a senior judge who was filling in for me, and Mr. Fortune was here for you. And it's a funny bond order, just in the sense of the format. It's not on our usual bond form. And no, it does not say what Dad says. It says that he shall stay entirely out of the Atlanta Judicial Circuit, which is Fulton County. They're one and the same, except lawyer, doctor, church, school, not work. So it did not include work. I'm not saying we can't change it, but that's just you're misremembering what it said. But that bond order didn't include work, and you had the curfew of 9 p.m. to 7 a.m. But you were paying for the ankle monitor. We then had a conversation, and I modified it on March 9th, back on a normal bond form. And it says you're going to stay out of Fulton County. I just copied the language, except for lawyer, doctor, church, or school. Same curfew, and then you have to reside at Guelph Circle. Is that your dad's place? So you're staying where you need to stay. I don't mind adding work, but I want the state to talk with the victim and weigh in as well. And they didn't know today that they needed to do it. So I'm going to have Mr. Patterson work with Ms. Smith. She can do some outreach, and then we'll just do this via email. We don't need to get everyone back in court. But know this, Mr. Turner, unless and until the bond is modified, you got to say no to the Instacart routes that pull you into Fulton County. Because that monitoring company, they're good, it's automated, they get it, they send it to me. I reach out to Mr. Patterson saying what's going on. And I'm not finding that you're willfully violating it. It's for a good reason that you were in Fulton, because you're trying to earn some money, but you can't do that until we change the bond. And I don't want to think about changing the bond until the state has a chance to think about it and talk to the named victim. Okay?
Okay.
All right. Ms. Smith, is that something you can start doing early next week? Since it's a civil trial calendar week, I'll be out of your business.
Yes.
All right. If you could shoot an email to me, Ms. Nelson, and Mr. Patterson when you've had a chance to do that. And Mr. Patterson, if we get to midweek and you haven't heard anything, just send an email to all of us. That may remind Ms. Smith. She's got lots of things she's taken care of. Okay? So until you hear from your lawyer, he'll know once I say I'll change it. And what I'll do is I'll send an email saying, yes, I will change it. That email is enough for him to tell you, go ahead and work in Fulton County. You don't need to wait for the bond order to catch up, because if you get a exclusion zone violation after I sent that email, the bonding company hadn't learned yet, but I would have given the green light for it. Okay? Questions?
Can I ask one more question?
Yeah.
Okay, so I got a job in my area now that they're accepting me in, which is Walmart.
When you say in your area, meaning in Hampton?
Georgia.
Okay.
I wanted to get more hours, so I wanted to see if you can accept the fact that I can work longer than the time that I can work now.
What are the hours?
I go in at 2 and gotta leave at 7:30. And
Oh, but you'd like to stay later than 7:30?
because the amount of money that I gotta pay towards my fees is not adding up with my check.
When you say fees, tell me what you're talking about, because we're paying for the monitor now.
My bond and my lawyer.
Oh, those fees, those are important fees, and you need to pay those. And it's a big old bond, and it's a fancy lawyer, so you do need to be earning. Same situation, I'm very open to modifying conditions of bond that are linked to school or employment. And that's a simpler one, because you're not going into Fulton County. So I would think that Ms. Smith would be less concerned if the curfew shifted from 7 a.m. to, I'll make it up, 11 p.m. So that you could work later at Walmart. And then you're in Clayton County that whole time anyway. We might not need to modify the exclusion zone. Which, would you do both? You would do Walmart and be doing the Instacart, or you just like to do Walmart only, but work longer at Walmart?
Right now, I like to do both.
You'd like to make as much as you can. Okay. Talk with Mr. Patterson, get the specifics. What I don't want to say is, hey, he can stay out as late as he wants. You would need to say, my shift ends at time X. And if I leave Walmart at X, it takes me 30 minutes to get home. So we need to have the curfew 30 minutes after the end of your shift. Get that to Mr. Patterson. He will get it to Ms. Smith, and then we'll talk about it. I don't think any of that will require you to have to come back in here, but we'll see what the state decides its perspective is going to be.
Thank you.
You bet. This is your last chance for questions. That's it?
Right. No, they're not going to do that.
Nah.
Okay. All right.
Thank you, Judge.
You're welcome.
And have a great day.
You too.
Judge,
Yes, ma'am.
really quick, Ms. Willingham went out to go home with victim from this case, see if he'd be opposed to that,
Oh, in Mr. Turner's case?
Yes.
Okay, well, here's Ms. Willingham.
I'm texting them now. They
Okay.
didn't answer, but they just text back.
Okay.
either way, I'll just update.
Yeah. He
I
can,
was trying to get an answer before you.
no, I appreciate the real-time thing, but this got dropped on you. I wasn't thinking, where's the answer from you all? I was trying to give you a few days next week to do it, and he can leave Walmart early until then. So if you get an answer while we're here, but let's just do it through the email.
Okay, I do have a question real quick, Judge. With cases like this, I didn't see anything in the, like anything filed telling me the reason that we had this, like ankle monitor issue. So is it something where if I see something like this on the calendar, it's always like some type of violation? Or do I just need to inquire on why it's on the calendar?
It would usually be a violation. The violation notices get sent to someone in court administration, and then that gets pushed out to the judge whose case it is. It also gets sent to about 5 people in the DA's office.
Okay.
So they probably get 1 million a day because there are a lot of ankle monitors out there. But really the way it was meant to be designed is that there's someone in your office who gets them and says, all right, Correll Turner, that's that case. Oh, that's Ms. Smith. And they get it to you. So you got notice when I got notice of what the violation is. Nothing wrong with reaching out to Ms. Nelson to say, hey, what's the issue? And she'll just forward you what I got, which is this automated report from A Second Chance that said, whatever those specifics were, this nice little box. It lists the condition: stay out of the circuit except to do these things. And then here he is at 4550 Jonesboro Road between 1:16 PM and 2:35 PM. And we think that's a violation. And it was. There was apparently a good explanation for it, at least this time. I was a little less spun up because it was in the middle of the day of a weekday. And like I said, if it had been 3 AM on a Saturday, that would have been more problematic for Mr. Turner. But that notice that I have in front of me gets sent to your office to, I think it's a generic email like ankle monitor violations, but it's monitored by 4 or 5 of the people in your office. And they just need to figure out if they're gonna make the effort to push it out.
All right, thank you, Judge.
You bet. Did he have something in his pockets? He got really sweaty really quickly. Okay, I was waiting for you to come out with like a gun and drugs because he was. Okay, so it was like instant sweat.
No, that's what you told me.
Yeah, no, I know. That's why I was wondering, because we've had it happen before where someone gets super agitated and it's no one wants to go into custody, but it's because basically now I have a whole new case because I had 18 bags of marijuana in my pocket. Usually it's not a gun because in theory they get stopped at the metal detector, but some stuff makes it through, and we've had amazing amounts of drugs show up.
Okay.
Oh, this is what the case with Judge Edie is? Yeah, you recognize the names, huh?
A whole different.
Yeah.
Tuesday, I was So I guess he told his attorney before, so the attorney told him he may take me. So by the time I called, probably you looking for him, go.
He's gone.
Yeah. But the attorney was like, well, I'm obligated to tell him, well, you may go into custody. But I didn't know the charge. Mine didn't charge him. Kidnap, terrorism threats, ag sexual battery. It is a non charge.
So I'll be engaging with those 2 judges, NC1 and NC2. It was brought to my attention by some of the sheriff's staff that the judge is letting the lawyers know, and then what you saw happens. And that's not how it needs to work, like what you just saw, and not the, hey, psst, because then people are going to disappear.
Because we try what we do, I walk in. I didn't feel it. Me and Pierce was good enough. He always.
Yeah, so ideally someone lets the judge know in advance. Sometimes we don't figure it out, so I may get, like you heard Ms. Simpson say, hey, check your chat. And so we're a little discreet about it. And then one way we've dealt with it, and some judges do, is they say, hey, Mr. Gatlin, I need you to sit in the jury box. And so then he can't, right? But because you're there and sometimes Ms. Simpson, I don't like doing that. So our deal is just, we know, but we don't talk about it until everything else is done. It's like, hey, there's one more thing we need to talk about. And
I've been in the jury about it. Hey,
yeah, I can. I just soon, you not have to be in that situation. And I'm fine with you sitting right there, Ms. Simpson sitting right there. Because as long as we don't bring it up, we're good. There were a couple others, we're like, hey, what are we
in
doing?
the past, I would tell them not what to tell the jury. She would say that.
Yeah,
Till we got to the case.
yeah.
Work today, huh?
On the go.
That's it. I'm gonna make a copy right there.
So I will come back if you guys will let me know when Ms. Rios is back. All three of you still have? She's keeping you busy. All right. Well, thanks for hanging out.
Did you take that? I mean, it's back.
No, that was for him, if he wanted it.
No, I already.
Okay, great, then souvenir for you. Appreciate you coming by.
All right, good.
It's not.
So and that's possible. Yeah, but we have to say announcing it and not letting the deputy know, which should like people run the deputy. So we just need to be a little smoother about it, but 100%, I mean, like in theory, Ms. Rios could figure this out for Gatlin, because I just looked, once they told me, like because sometimes it's in the system. Sometimes it's not. This was one bright red. And that's like it was 20, it was this date. So it was knowable, and that could very, I got, there's one for you. And then you're gonna make your own decision. And I understand the decision that got made. It won't end well in the very, very end.
Yeah, no, we still have a couple more, but I don't think is anybody else in custody?
No, I don't.
Okay, I'm right there.
Yeah. Motion to do. Cause I just look at.
Hello, Mr.
She's in the hallway talking to other clients.
Yeah.
I'm ready to see all that out there. But I think offers me to keep going to theirs. So much hard to try to stuff on the table. Yeah, but anything I thought would be that is still a solid charter. But you're that part of Stephen. If the car was stolen out of the camera, he was charged with introduction to camera. With that kind of Stephen, you would have to see. I saw the, and I'm still the actual, that document, but I saw the affidavit or the cab that prosecuted, but it was another vehicle. That was a BMW. Well, no. You need to see if the cab had, where was the vehicle located when it was stolen? You may need to see where the actual theft. And then, because if he was charged with actual, that like, if I'm charged with the actual theft of the phone, you can't also charge me with the theft by receiving. In another county. Correct. So what document am I looking for? The incident report where they, the incident report on the cab where he already pleaded on. And it doesn't even have to be if he is the suspect in the theft, if the cab, well, technically, if the cab told not to leave there, then yes, we could still have to pay on the theft by receiving. But if the cab charged him with a theft, so that's what you, or the incident report, so that you can go to the cab DA's office and be like, hey, did y'all charge him with this theft? And you say incident report, you talking about my incident report or theirs? Theirs. Okay. Theirs. Which you actually may be able to get all that information. Because if I'm just saying he represented him in this case, the money should already have that information.
Okay.
And if Kalani's information shows that the theft is for this vehicle, then you can't move forward on it. Or at least on the receiving. Now, the identity, I don't know how you.
Yeah.
That's, you could be charged with that, that's one.
Because what we're talking about is that that's the issue. That no process for the cases, I mean, those charges, he just said, most probably each different things that it is, which.
Yeah, and I think those are still.
It's not, because it's. Okay, good to know. And, yeah, next thing.
Okay, those are all, so all of my cases today. So Mac is the only one that's still left.
It's 28 position caps. Of course, still 4 court for cases. Excellent. Also, for all of it. Yeah. It's some service. Oh. So, there's some service going on, so you're still. Even for what will come with it on the.
If they were to flip, you know, if you had never done like a proper thing,
I asked you to option. Defendant, new defendant. She's good. Yeah.
So as I was reading it, I'm like, is this the case? And then it's the bamboo bar and the plug, the line.
Yeah, because that's what I was, when he said it and I looked, I was like, wait, they're both batteries. Then I was like, let me just look. But then when I was looking, I was like, okay, wait, no, I think these are different cases. Because sometimes, you know, they'll transfer from state court to us. So that's why when they said it, I was like, wait, let me check. Not that I could have done anything about it today, but I would have. It's the same thing.
I thought the same thing, but the warrants for this case were also in the system.
Okay, I got 2 more. Okay, because yeah, I was like, let me check, because I want to make sure.
Yeah, I thought the same thing, but there actually are 3. 2 are for this case, and then 1 was something separate.
We're gonna just move it to a trial calendar, because I didn't.
I'm not reserving for because the offer has been on the table. I understand that we can cover him, but that's on him. So I am going to reject the reserving. Okay. But that's fine. I just want you to know.
Yeah.
If you ask that, I just didn't want you to be surprised.
I'll ask them to see what judge does.
Yeah. Because I know that you have been trying to touch. Check for the reserve. Either it's not here, but he's not here. I understand, but that's the one. I understand.
How you know
Do all the staff. We'll talk about this later. No, I think if I recall, he was also one who had a. He had something to pass. That one I said. Or he had to go down this screen or something?
No, that was Rosser, but I think he might have something too. But when I watched the video, she literally was like, she literally says, I pushed him first. She's like, I hit him first, she's like, I pushed him first.
Yeah, you know, it's not. So that, but let me look.
I think she'll look better. I think it relates to the pictures of her maybe.
Was predominantly aggressive, is it necessary? based on your interview, but I'm gonna address the.
Case number 4, so it's
You
just,
know, There's the history that she can talk about, and if she can stuff like, I don't understand.
Let's keep talking about it, and we're gonna find out he would, I think, he was saying that they were a mutual fight, she's in hand, they would do whatever. I think we need to get this down. So that's part of what you do. Stop. Other commissions.
Let me look at the GCIC, because it's the fact that one of them, I don't think. You can't get it, that's the problem. This is a substitute conviction. There you go, you can't go, I'm not going to listen to things. At the matter of substitute, it's only because they have that kind of listening pattern. So statute.
you heard it on the radio, that was 436.
What's called?
Oh, I'm sorry, I keep calling.
Before I go back out, I'm not prepared. What was the new information about him? Larry, what was the new information, what did you want to talk about? Of the 2 blanks.
So, you know, I know 2009 was just like, exactly. A childhood year, is that childhood year?
He was trying to give me information about, because I think the deep dive case is closed.
Yes.
And the child's injuries, it seemed like it was like stinking, gone, you know.
Ever seen the picture?
I haven't seen the room back, look at the pictures.
I can't remember. It does seem like that, but then when I saw the pictures, I was like, Jesus. And apparently I know that there's some allegations that the little boy was attacked by a dog prior to that. Which I don't know that that was ever recorded, which I think is problematic too, but because if some of those healing injuries are from a dog attack, then that should have been reported as well.
Is he connected on the move? Maybe they were showing kind of just like thing. So I don't know how many people reach this. Better than
So here, all of those red ones, and then underneath here, this, and I know they're gonna say it's from a dog bite, from a dog attack, but this looks just like the injuries he's just gotten. And then he's got that one on his, he's got those on his back.
So I don't think so. I mean, but I'm trying to confused to which charge, look like it should be the charge, but it's given a pay for it, so it would be a misdemeanor based on it. This is low my salvation thing, so I'm assuming that was just this case, and that was so, yeah. So he has that.
I think it's the same. I'm good.
He's first with was she cut it out for interpretation? That's actually the low fight. Because can we do fire suspended? So I, the way actually, which is why I don't remember. It's all about the statute.
It's just tricky.
Now it's, but oh, and then also,
And most of the time, depending on the people take it and go. It used to be 5.
And that was just 3 days.
yeah, I mean,
I be saying 7.
I go for emergency. motion to vote bond yesterday, but I asked the. What exactly was the bond modified, and I just didn't see it, because I didn't see the modification. He sent it. And he's looking at it. Or it's like kids. I remember the age.
You both got retrial, so, is Willingham?
Yes.
You're in trouble. No.
Okay, so.
You're not in trouble, but you do need to come this way. I think took away this.
Oh, it's over here. Ms. Rios is on punishment from Katie.
No, I think that Gordon doesn't like it to be on that table.
We have questions about how the drugs will make a straight probation, but with the extent of the injuries, and then we've got older healing injuries.
Yeah.
And I mean, I guess some of these could be puncture wounds from a dog.
Yeah, that's what it looks like.
But some of these look just like
Could be
what he has.
could be scratches from the dog. Seems
I
like
mean,
we're
and-
gonna resolve it
And
today.
a jury could believe that, but a
Yeah.
jury could also believe that he's. With forensic interview, he said that he had all of those. Then he was getting the picture of his to identify. He said that it wasn't his dad, and then changed his dad's name.
Okay.
So yeah, watch the forensic, look at the picture.
Okay.
Yeah.
He's not moving. We have to wait until the judge is on the bench. Or is it?
I was trying to get that motion information off the list. That's just his side, but his arms is what got him sent to.
They lost for 16 games, though.
His
The reason they lost was because it was up to 10. They probably rubber Jordan record.
He just
I'm saying it's crazy.
Oh, my mom was getting that. Overseas, that's yeah, I know, but like, how you try to can't watch?
it can't be just like it's gonna be 27 first off. Number two, so we can't come out there. The registry, you can come out, you can apply to come out at level 1. Yeah, level 2.
Like you said, you did something.
Like, okay, like some of these circular ones could be punctual, but that looks just like that. Because they say I was attacked by a dog. Which to me is how it's bad, because if he was attacked by 2 dogs on his house, it's still.
Oh, basketball. Well, you do it, I mean, I don't know. They are.
We're just, evidence that's common P drive.
I don't think that's what we.
No.
You did something today, or you know?
I did it. Based on all right.
What's that? You proud, you know, bang, look about that.
Shoot, we can negotiate.
No, you go ahead.
What I got, like, like a solution.
Let Allah. It's the ones
What
that.
was the violation? He was around no contact.
Well, you found an emergency, if that's something that's sensitive to the we can invest.
Okay, one better do on 2 Friday. Every day. It did not click. Oh, I'm telling you, I'm getting it.
That's it.
I heard you from there.
I don't know if it should be like, one time, we'll take that.
What's new?
Feelings. Just the feeling.
Yeah, it's but you'll be right back.
Yeah.
What's that?
Oh, yeah, on it, bonus. No, that's gonna be crazy.
What did this happen?
What you want?
And not granted, it's moved slowly, but it's not, I don't feel like that, it was July, that's the first day.
Yeah, on
That's all the cases.
I usually go, I go stop, golf,
Most of them do.
golf,
Most of them.
this one. My own,
So it is one.
not even my own, this shit, you know, too now. This shit a little better than two, I do.
I've seen spanking going too far. She just, that's not it.
Yeah, no, you can about the first 6 weeks. Or I go like, Shot Island, yeah, or,
Biggest worms. Great.
I'll report that it's going.
Oh, yeah.
Please.
Yeah. Okay.
Can we be? Like, I have every game of the season, I have, I did all the running back. I do them on
Psych.
Asian, Henry.
Walker. See,
It was 6 on
okay.
the Gatlin, yes, you can. Yeah.
I was a killer.
Then when he come back to school, 4 times that. I was so mad, man. $50, 16, I think brought me like 3 games. 5 out of the season. Just tell them, don't tell them. No. See, if I would do that, I probably won, but I didn't on the bottom. Yeah, he come back the next week, 3 times. I'm like, I guess.
I really like that when we. That was when quarterbacks, right? Demons. In the half.
Don't
I did 6. All right, good. But Mark, yeah. This is
all in,
all in. He come back the next week and go like this.
No, he said they got, he said, what's one?
I'm gonna say it was crazy about it.
He said, he did
The
all
only
the
thing I don't understand it, but the only thing around.
What do you mean, like, that stuff, same thing, or?
But sometimes they win for me, so. I could have done it, I just took that.
I don't see that on you. Yeah, boy.
What's your opinion? And then the other person heard the opinion. You can run a concur. And yeah, so that way, if it violates your probation, you don't have to worry about trying to figure out what's going on with the other.
Awesome.
Okay.
And the only way we go see team on that. Even. So somebody.
Just the one, right?
Oh, I'm sorry. That's okay. I wasn't sure. I remembered Ms. Rios' mic.
You still out?
She's still talking? Okay.
Yeah. Yes. So just keep talking. There's more, yes, there's more. It wants something.
Two more times, yeah. Great.
Wait, you were gonna ask me something before.
Yes, two things.
Sorry.
Which makes sense.
Mainly because if you in a situation where
It's hard, you can talk, sometimes it's people. So it's not over. Still in mind. But I would take off.
or you got to shoot it. Yeah, that's not. What about, as you said that I thought about financial. First time, one of them.
This goes, this one, man.
Okay, yeah. That's the wind chill. That's the money lot.
So I would be the case on there.
I'm sorry, this is.
My big guy won't go against it, so one time, he was already a few days. You know, they most confused. Take that away. Maybe it's gonna be lonely. I will go back and forth. Just, you know, yeah.
That one just wrong. So, what is going on? You see the
That's too bad. I didn't know what practice.
Yeah, keep going.
Yeah,
Yeah, we thought about treatment and that. Yeah. I thought about going too.
They,
Yeah, now I'm going.
damn.
I want some. Oh, yeah.
This is a great, that's what, CD House did. So.
Yeah, Steve,
She could remember my.
15 times, they were, before she got hurt.
Huh?
15 times, what she got hurt.
Wait, I just.
Ticket.
So.
See the ticket. Amen to that.
They got 5 games just for me state. 2 of them in the house. Whatever Chicago, I don't know why. I think 1 Dallas, that one's crazy.
That's what people just came.
They got 30.
Well, thank you. Oh, I'm sorry.
But.
You just get so much.
Vegas wasn't this one, right?
Yeah, I'm looking it up now.
They want to talk about. Jackie Young. And it's. What's the other name? I can't see that one.
It has to be consecutive.
Is it? It's Asian, but. The game raising. There's a better see first.
That's why I always say that's
I'm gonna make something where that's a straight line. Taking 100%.
And then, you know, they just did a new deal, so, yeah, they got paid now, so that's all they, see, so like.
But man, it's crazy.
That's my. So we came to that.
You keep going to the hall.
Make sure to, yeah, I'm gonna read it refresh it. I have my.
That's the people that are like.
They have.
Yeah, that's, yeah, it was like, stopping the coach in for you.
When I heard you even before we get down. You guys get two.
I was just,
Okay.
all alone.
Mickey. Hopefully they play the right. We're gonna do some playoff team. They made it.
You see what he got. You see what,
The Hawk, they do something, right? That did that,
yeah, too.
like last year. Oh, yeah. So bad, 3 year old.
You like,
No.
yeah, what's up in the gentleman there? 11. No, not 11.
Hawks.
Yeah, the Hawks, the young boy. It's not young, no.
They got Jalen Johnson. What's her name, ball?
It's him.
Who?
He?
Oh, yeah, but Plea.
Oh, but they gonna marry. They'll be, Charlotte.
That's the thing, Orlando.
Orlando. Oh, all of them six.
See, they can fire before they off the key.
Who we gonna get in this?
I'll got 2 tonight, Sunday.
So, yes, yes, you hate that.
Who might have got tonight?
Only got Williams.
See, they're gonna be doing that.
Only got Williams. And then Hawks.
Who Orlando there?
On the ground?
Yeah, just to get an ETA. So the answer to your question about next week is that my civil trial once again has settled. So we will be able to take pleas next week at a time that works for you all. I think Ms. Nelson is out next week. That doesn't mean we can't do things. It just may be a little, I may be the scheduler, so I don't know, maybe like 7 a.m.
Maybe beneficial for one or two else is fine. Very much so.
And then I always say he cannot be around the child.
Oh, that's what I'm saying, that wasn't modified.
Cause I have to look at, see that, cause everything, if that's not true, then just can't be at that address, and she's. So I guess, look at what the bond order actually says.
Ms. Rios, I'm going to interrupt just for a quick second. I'm not rushing you in any way. I just wanted to check in.
We can get some people out.
Okay, we've got we got plenty of time if you need more time. And next week's civil trial, someone who got rear-ended on 75 South just settled. So the week is open. There are no scheduled calendars. I'm not going to drag anyone in, but I'm offering that up as time to bring people in, like Mr. Rosser, if you wanted to bring something in. Okay? So if there's something we can do now, great, but I'm also happy to go back and do other things.
We can get let's talk about Mr. Preston Cobb.
All right, Mr. Cobb.
No, we're gonna talk about, he's gone. I'm sorry, Michael Mack.
Oh, so Mr. Cobb is gone.
Yes.
And what we did with him, because of some difficulties, I don't know if it was dash cam or the black box information, is that he's moving to the trial calendar, but we're preserving his final plea rights.
Yes, Your Honor.
And you are going to work with Ms. Smith about whether his bond should be modified because he's not supposed to be driving.
Yes, sir.
Okay. So trial. Got it. So that's Mr. Cobb. So we've got Mr. Mack and Mr. Walker and Ms. McGee Russell. Who did you want to talk about?
Mr. Mack, if we could just go forward to the trial calendar. His phone was off, so that's why I wasn't able to talk to him prior to his court date. So I would.
Which one's Mr. Mack? There he is. Off meaning it was like out of service, or he just was ignoring you?
Out of service, right?
It's out of service. I ain't got a phone.
Okay, so you have a phone now, and how long is that contract for? Is it good for a while? Okay, so you've got his new number.
Yes, sir. And I'm asking for it to go to trial calendar and for the rights to be preserved. Because he just found out about the offer, but.
The offer that today was the first day you could communicate the offer to him?
Yes, Your Honor.
Okay, that's fine, hold on.
Record, Judge, the state would actually be objecting
Oh.
to that to final plea rights being reserved.
Okay.
Because that offer was extended a little while ago, and Mr. Mack knew he had final plea calendar coming up because he was present at the plea and arraignment calendar.
Ah.
Although Mr. Mack may not have been reachable, he knew how to reach his attorney to provide her with his contact information. So although we obviously have no objection with it moving forward to trial calendar,
Right.
we would object to the final plea rights being reserved.
Got it. Mr. Mack, did you get something in the mail telling you to be here today?
Yeah, I got something in the mail. It goes to the grandma.
Well, that's fine, but however it was, someone got to you the letter that said you got to come to court.
Yeah, they showed me that I had a court week, but they ain't showed me the letter.
Okay. I'm gonna have you come up to the podium, and Ms. Rios, if you could please be with Mr. Mack.
This is your number, right?
All right, and Ms. Rivers, we're gonna get on the record, please. This is State versus Mack, 25 SC 006737. Mr. Mack is here in court with his lawyer, Ms. Rios, and Ms. Willingham represents the state. Ms. Rios, I know you shared before we were on the record that you've had a little trouble reaching Mr. Mack, but you feel like you've got good contact information for him now.
Yes, Your Honor.
And Mr. Mack, do you have a good number for Ms. Rios?
Yes, ma'am. Yes, sir.
That's all right, in your phone?
Yes, sir.
Great, okay. Ms. Rios, any discovery issues you've identified?
No, Your Honor.
All right. Ms. Willingham, what is the state's offer to Mr. Mack if he wanted to resolve the case today?
State's offer is a overall sentence of 8 years probation, 3 years probation as to count 1, and as to count 3 would run concurrent. As to count 2, 5 years probation would run consecutive. The state would be asking for no violent contact with the victim, to complete Families First, complete family violence intervention program, and complete 60 hours of community service, have no weapons, and seek and maintain gainful employment.
All right. Have you been working, Mr. Mack?
Yeah, like I said, I sell T-shirts.
You sell T-shirts?
Yeah.
Okay. Do you design them or you get them and it's like Braves T-shirts and?
Like how you saying?
Okay. Well, I said both. Do you design them or someone else is designing them, but you sell them?
Yeah,
The second one?
yeah.
Okay, got it. Where do you sell?
Like concerts, football games, wherever I'm going.
Got it. Wherever they're big crowds.
Yeah, like
Okay.
where a crowd at. Really.
You're going to be selling at the World Cup?
Yeah, hopefully I am, and I hope they don't lock me up either.
Yeah, they're going to be pretty strict about that. Be careful on that one. You do you, but that's a whole nother show, the World Cup. So just be thoughtful about it. Maybe be way out at the edge. Don't be too close to Ben's if you're selling like a Go Spain t-shirt or something. Mr. Mack, do you feel like you understand what the state's recommendation is? It's a pure probation, but it's a felony. It'd be pleading to a felony, 8 years probation with some conditions, basically some classes you go to and no violent contact with whoever the named victim is in your case. You feel like you understand that offer?
Yeah, I understand it.
Okay. Is that something you're interested in pursuing today?
No.
Okay. You don't have to. What I'm going to do is move your case to the trial calendar. The only thing that changes after today, same lawyer, same prosecutor, same set of facts, whatever the facts are in this case. After today, you can still enter a plea if you want to do that. What you don't get to do is withdraw the plea if the sentence I impose is more than what Ms. Rios asked for. And let me break it down to numbers. We know today Ms. Willingham was going to ask for 8 years probation. Ms. Rios might have asked for 5. Say, hey, you know, Judge, here's why we think it should be 5 years probation, not 8 years. If I were to give you anything more than 5 years probation, 6, 7, up to the 8 that the state asked for, today you could withdraw your plea. You could say, I appreciate that, Judge, but I was willing to do what my lawyer asked for. No thanks, let's go to trial. Going forward, you can still enter a plea. You just don't get to say no thanks if you don't like the sentence you get. So if 2 weeks from now we're here, you want to take a plea, you want this to be done with before the World Cup, so you can go sell the T-shirts. And the state recommends 8 years probation, and you don't have to keep that offer open. They may say 10 next time. They're going to say what they say. Ms. Rios says what she says, and if I do something different than what Ms. Rios asked for, that's your sentence. That's the big change. Is just you're stuck with the sentence you get in a guilty plea, just like you would be if you go to trial. If you go to trial and the jury finds you guilty, you don't get to negotiate what the sentence is. You get what the judge gives you. Understand that?
Yes, sir.
Yes? Excellent. Any questions about anything?
No.
You'll stay in touch with Ms. Rios?
Yes.
Your case is on the upcoming, well, I say upcoming, in about a month, you'll need to be, at the latest, you'll need to be back here for that trial calendar. May 7th, it's a Thursday.
Date? Oh, damn, May 7th.
It's May 7th. You'll also get something in the mail at what I guess is your grandma's.
3239. Yeah.
I'm gonna look it up right now, make sure it's going there. But as long as that's the safe place for your mail, that's where it's gonna be going. More importantly, you've got a new phone and you shared those digits with Ms. Rios, because she'll call or text you saying, like, you gotta be here on the 7th for the trial calendar. And that'll be the time either to work it out if you haven't, or to say, I'm ready to go. The address is 3239 Columbia Woods. Who is there?
Grandma.
All right, and she's good with mail?
Yeah.
All right, she'll let you know if something arrives.
Yeah.
Okay, Ms. Rios, anything else on behalf of Mr. Mack? There was a little question mark about a warrant. There's not a warrant, but I want to make sure there's nothing that he needs to be mindful of. Do you know anything about it?
It's old, Judge.
Oh, it's old.
I know about it, but it be popping up, but.
Something in DeKalb County. Yeah, and we couldn't find out anything more about it. Not enough to say we got to take you into custody.
I got locked up for it. Oh, I believe they just still got it like on my record.
Okay.
They're supposed to sponge down my record.
Okay. Well, I don't know if did you have a lawyer helping you in DeKalb?
No, I didn't. I ain't gonna.
Okay. Well, it does pop up, but not in a way where we need to do anything with it. I'm just letting you know. You could get pulled over someday and the officer might not have enough information, and that officer might say, I got to take you. So you might want to figure out how to make it go away. I don't know, but you're good to go for now. We'll see you May 7th at the latest. You and Ms. Rios may work something out before then. Come on in. We'll take care of business.
Okay.
Ms. Willingham, anything else in the MAC matter? All right, thank you.
Judge, that concludes my business.
Yes, ma'am.
Can we talk about Miss McGee, Deja McGee? So I've talked with her.
Yep, come on up, Ms. McGee.
McGee Russell.
Yep.
She's on. Okay.
You want me to do it?
Yes.
I got you.
Good morning.
We have, me and the state have talked and we're gonna do a referral to behavioral health court. She's willing to participate in that. Now, I think that if we can, if it's on the May 7th calendar, if we can remove it and put on an inquiry, just because she has a mental health diagnosis, but she currently doesn't have insurance. So they're gonna have to figure out where she can go to get her documentation, for her diagnosis.
Got it. So something you can speak to, but there's just not paperwork to document what a doctor has told you.
Yes.
Right now. So you'd need to go to Grady or somewhere to get I guess we'll call it a re-diagnosis, because BHTC, which is a great program, they would need to basically see it on paper, which isn't that anyone's doubting what you have to say, but sometimes the doctor puts it in a certain way where they say, oh, great, we can make the program go this way instead of that way to address whatever it is the doctor said. So you're asking for a little more time to line that up.
Yes, and I have good contact information for her now. Her phone was off or she.
Yeah, I lost my phone and yeah.
Okay. How often do you lose phones?
Nah, it was kind of stolen, but nah, not often.
Okay. So you think this one you'll keep for a while?
Yeah.
Okay. My thought, Ms. Rios, is that we keep it on the trial calendar, but for inquiry purposes.
Okay.
Because this is a built-in date.
Yeah.
We'll be able to see Ms. McGee Russell. She's not on until the end of May calendar.
Oh, okay. Well, then, yeah.
So that's a while, and there's no need to wait that long. It sounded like Ms. Smith was going to put the referral in. And Ms. McGee Russell, you would be meeting with people from the accountability court intake team. They just want to get to know you a little bit, understand your needs to make sure it's the right fit. We don't want to put someone in a program who doesn't need the program. But one of the things they will need is ultimately some documentation of whatever the diagnosis is. So you have two projects. One is to meet with the accountability court folks, and Ms. Rios will help arrange that. But the other is to get with a doctor, whether it's at Grady or Mercy Care or your own caregiver. We don't have to pick it for you, to get that written diagnosis.
Okay. So
All right.
you get like a re-diagnosis? Okay,
Right.
gotcha.
I don't know, Ms. Rios, have your clients told you, hey, the people from accountability court recommend a place to go to get a diagnosis, or they simply say?
I thought they did recommend a place to go, or they help people trying to find.
I hope so.
Yeah.
That would be part of the intake process.
Yeah.
And so how does it flow? If Ms. Smith submits this paperwork, because Ms. McGee Russell is out on bond, they're not going to know how to reach her.
I'm gonna give them their number. So usually I've had people out on bond get interviewed with Joe Court. As long as she answers her phone, they'll call.
So they go directly to the client. They don't go through you. They don't say, hey, Attorney Rios, please arrange for your client to be at Hope Hall at this time.
No, they call them and then they have them come in to go meet with them.
Yep. Okay. So please do engage with them. Again, if it's not the right, no one's forcing you into the program. The whole point of the intake is to make sure it will work for you and that the program can actually support you in the way you need to be supported. So please do meet with the intake team so they can say, yep, it's great, as long as we get that diagnosis, or this isn't the right program. You'll be back here on May 28th. Did you get something in the mail telling you, how'd you know to be here today?
Ironically, my grandfather, the person that's on the case.
He is the named victim on the case?
Yeah.
Oh, and
Like-
did the mail go to him?
Yeah.
You spoke to him and he told,
Yeah.
got it.
I didn't get the mail though.
What we have for your address is two different addresses. There is an apartment on Peachtree Road, and then there is a Plymouth Lane address.
You can send it to the Plymouth Lane.
Okay. I don't know which one they use. They're both listed. Maybe they send it to both. Let's see.
Why would, I never put a change of address. I don't know why would it have something to do with the DMV as to why the second address is listed?
Well, you did do a change of address on January 13th. And that change of address said, please mail to 3380 Peachtree Road, unit 1410. Ms. Rios submitted that for you.
Oh, okay, I didn't know that.
Is that a good address for you?
No, you could change it to 526.
Put it back to, it went away. The Plymouth Lane address?
Yes, sir.
Okay. Do we have a change of address form? If you fill it out, I'll get it to Ms. Nelson. Thanks. Ms. Smith, were you envisioning Ms. McGee Russell's case a plea into BHTC, or was it a diversion?
Diversion.
And that's something you've discussed with the grandfather?
Yes, well, I talked to him about options that we had,
Mhm.
from his perspective, so I'll be calling him again.
I'm sure you will, but he didn't seem like he'd be opposed to plugging Ms. McGee Russell into a support network like that.
Right, in fact, that's something he said he wanted her to get some help. He's opposed to sentencing in jail and stuff like
Got it.
that. But
Okay, that makes sense. Okay, we'll try to remove the Peachtree Road address. The Plymouth Lane is already in there. I just don't know if they send things to both or not, but we'll try to get the other one out. So you need to meet with the people from Accountability Court and get that diagnosis. You will get notice to the Plymouth Lane address, but also Ms. Rios will be reaching out to you at the new phone you have to be checking on you. Did you meet with Accountability Court? How's it going with getting a diagnosis? And I'll see you when it's time.
Okay.
Any questions?
No, not right now.
Okay. Ms. Rios, anything else?
No, Your Honor, thank you.
Ms. Smith?
okay, perfect, thank you.
Okay.
Is she free?
Yes, okay.
Oh,
You're good.
I'm good.
We're texting one. I'm sure we're gonna stay.
My starting point is to this. Whereas after this case, which would also violate his bond for possession of firearms. I'm trying. Yes. Me. I'm trying, bro. Yeah. He's making it because I'm challenge station. He got 15 years straight probation. Right, it's really like I'm on it. I'm on it. I'm trying to say anything else. Jeez.
Pardon me? Who do I have? Man, ever since the Warriors have tailed off, that's where I grew up. The Warriors have tailed off. I plug in a little less. How about you? Hawks. Well, they're looking good. I mean, a couple losses in a row, and they've been strong.
They got wins.
Yeah. Are they, I don't remember when I last checked, are they gonna have to play in or are they?
Tonight and Sunday, probably, so
Yeah, who do they have tonight?
Cleveland again.
Oh.
They was in Cleveland.
Yeah. That didn't go well. But they're better at home. And then what's their last game?
Miami, Sunday.
At Miami? Huh. Yeah. Well, if they lose both, they don't make it at all, or they just have to play, Any sense of who they'll play?
They lose, they probably drop 6. I mean, 7. 7-10?
Yeah, and then 8 and 9.
I think it's 7-10.
Yeah.
Cause if they know
10 play 9.
Oh, 10 plays 9?
8, 7.
That's not fair to poor 7. 7 should get to play 10.
but they get 2 chances.
They get 2 chances.
Okay.
They lose that first one, then they got to win it.
Okay. Huh.
They will play the winner of 9-10.
Yeah. Miami with 10 and then somebody with 9.
Oh, so the Hawks' last game in Miami is a big deal. Ooh, this is a Miami
It
fan.
starts tonight.
Miami had beat Atlanta the last 3 play-ins.
They always beat them. They never match up with
Yeah.
something.
Huh. Yeah, our household has shifted over to MLB now that that started because my kids play baseball. So my kid was playing 2K nonstop, and then baseball started. It's like basketball doesn't even exist. It's funny. Like it's like the playoff time. It's like, Dad, basketball playoffs are like 8 months long. It's always gonna be there. You're not gonna miss anything. They go on forever. That and hockey, like you just like there's. I don't know that there is an off season.
Every other.
And now with basketball, they have the mid-season tournament. Like, what? Come on. What?
That's so y'all be tuned in.
Yeah.
Want to watch it.
Yeah, it is. It's about viewing eyeballs.
But the playoffs started.
On through June, April to June.
I took a loss last night to the Lakers. Curry and Lakers.
He did? He must be waiting for Monday.
I don't know. He's
Monday.
getting fragile. How you doing, Miss Feely?
I'm well. I heard there was an episode of the Brian Steele show today, but I see it's gotten continued.
Twice. It's a fascinating story. Based on I have only read Ms. McGillicuddy's pleading. She was not wearing gloves when she wrote it. It was very well written. And so it will be the 21st or 22nd. And now it may just be a plea.
I was just over with Judge Landell, so.
Got it.
That's what I'm saying, you were saying, that's my story. Yes.
So Back in the day, case number started with Y.
Yes, way back. So there was A and then Z. For some reason, they went backwards. So before my time, the case would be A 1, 2, 3, 4. And when they got through all those numbers, then it was Z 0001, Z 1, 2, 3, 4, and then Y. And then finally they stopped with like, why are we doing this? And they shifted to 10 SC. And so that 10 would tell you it was an indictment from 2010. Yeah. But when I was in the DA's office, we still had a few Ys. Yeah. But yeah, if you see a letter in front of it, that means it happened a long time. And every once in a while we'll still bump into an A, but that's like a defendant who's 99.
I've seen Z and Y.
Yeah.
How long you been on this?
I just had my 14th anniversary.
Yes, sir.
Like yesterday or the day before. Arrington.
Anniversary.
Hey, thank you. He retired midway through one of his terms.
I got him 6. So yeah, I remember being on.
Oh yeah, you were here way before me. You've been here a minute.
Well, we were state court pre-trials, and we merged with Superior.
Uh-huh.
Started getting out of college.
Whew.
When you been working? That Friday,
It's a shooting? I was in the U.S. Attorney's office. So I was at work, just not in this building. Hello. We are doing a little shuttle diplomacy in Mr. Walker's case. I'm working on the Collier final disposition.
Oh, you're working on that. Oh, it's like.
Just send to you.
Oh,
Yeah.
okay.
I just reading it over.
I thought I was missing something because I thought we were done. I didn't know we hadn't finished longer about it. My notes said final plea.
I think that's about to be what happens, but
So I can do Tuesdays, I'll get them on to up to this. I can. Yes, we have one of the hospitals. For the long version. And she has a problem. So she made that's really before. Yeah.
He's with his ad.
Is Ms. Rios trying to work it out today?
There's some, like we said, there was some information about the case that I'm willing to work with today. So I think she's trying to see.
Work with it today. Okay. How you doing?
Yeah, and a copy.
You got it all?
No, you want.
Who want, Riley want to look? Riley want to look?
No.
No. Wait, Oh, that is good. Oh, we just don't go on very bad. Yeah, it's the week for me. Oh, it's good. And actually, working out.
We're gonna do a negotiated plea and a non-negotiated plea in a second. Sure. We'll negotiate so we can do. That's gonna go over the plea sheet real quick.
So we are going to go forward. You just need a little more time to talk to him?
Yes, I just need to go over his rights real quick.
Okay.
So what's the name?
This is Mr. Walker. You got him on here. Yes, look at that. It is. Wow. You've seen this guy's criminal history.
Yes,
Okay,
and that's what I was trying to work on today.
got it.
Yes, Judge.
Thank you so much.
I will be back in a sec.
All right. I was just gonna come ask for those. Thank you.
It's pretty brief. I mean, the portion of an issue was I'm thinking, I don't know, we're not negotiating, so I don't know. And it's a final plea, so I guess he can withdraw. I'm probably gonna. I don't know, don't even know this point. I will take it. Check her ears and all. Cheers. I can't even go to us on PC without the top box on God. Judge.
Yes,
I
ma'am.
don't think I have any other matters on the calendar for today. May I be excused?
Would you like to get out of here?
Yes.
Any exciting weekend plans?
My niece is having a birthday party.
How old?
7,
All right. Is that a local pardon?
turning 17.
We're turning 17.
No, 7, going on 17.
Oh, got it. She acts like, got it. All right. She's big for her britches. Is that a local thing?
Yes.
So you can go to it. That'd be nice. Good. Is there a theme? Like, is she?
It's Barbie theme.
Oh, all right. Well, good. Do you have a gift already?
No.
You're gonna go take care of that?
Yeah.
All right. Well, have a good time with that. And next week, like I said, was supposed to be the civil trial calendar. There are bits and pieces of it that are gonna slot in. It's not a trial. So if you and Ms. Rios or you and Ms. Wood sort anything out that you want to knock out that week, just reach out.
Okay, I think it is a couple of cases that we knock out this week.
Okay, sounds good.
Thank you, see you soon.
Bye. Let me know when you're ready.
I am.
You're ready. Ah, it was your binder with, got it, all the carefully, almost laminated pages. Ms. Rios, are you ready or do you need to
I'm
jot?
just writing my notes for my head again.
Okay, great. All right. Then let's make sure that we're good. Can you adjust the monitor a little bit? Mr. Walker is much taller than Ms. Collier was not tall, and so we had to adjust that. I want to make sure that
I'm sorry.
Ms. Rivers can see who's doing the talking. Ms. Rivers, you ready for the last criminal event of the day?
Yes, I am.
Great. This is 25 SC 007 409, State versus Walker. Mr. Walker is here with Ms. Rios, and we have Ms. Williams for the state. Mr. Walker, it sounds like after much negotiating, you are prepared to enter a plea in your case. Is that right?
Yes. Yes,
Well,
sir.
okay. Yeah, I noticed you, this won't show up on the record, but you looked at your lawyer like, am I ready to take a plea? Today is your final plea date. So you have an opportunity in this plea, if I sentence you to more than what Ms. Rios asked for, to withdraw your plea. So I'll hear everything from the state, I'll hear everything from your lawyer and you, and I'm going to impose a sentence. It may not be what you were hoping for, but you will have a chance to talk with Ms. Rios about it and say, I don't like it, but I'll take it, or no thanks. Let's go to trial on this one, and then we can do that. So I don't want you to worry that the floor is going to open up and you fall down into a cell if I were to say, hey, I think you need to go to prison for a year. And I'm not saying that's what I'm going to say. I don't know enough about this situation. So you'll have the ability to think about what sentence I impose, assuming I accept your plea, before you decide whether to accept it.
Yes, sir.
That's how today works. After today, if you say, I don't like that sentence, Judge, you can still enter a plea. You may not want to go to trial, but after today, whatever sentence you get is the sentence you get. You don't get to say no thanks to it. All right?
Okay.
So with that understanding, do you want to try to go forward with a plea in your case today?
I would like to try to go for a plea under Alfred.
Okay. So, and I promise we'll cover that as well. So it sounds like you have a disagreement about what the facts are in the case.
It just, I couldn't pronounce it correct, Judge.
Okay. Ms. Williams is going to share with me at the appropriate time the evidence that she thinks she could present to a jury. And then Ms. Rios will be able to talk about where there are disagreements. And because you're saying it's an Alfred plea, it sounds like you don't agree with what the state has said this case is all about. I can still accept an offered plea as long as I think there's enough evidence that the state could prove its case, even though you disagree with it. So we'll cross that bridge when we get to it, all right?
Yes, sir.
Ms. Williams is going to put you under oath, ask you a bunch of questions. You need to answer those questions truthfully. You also need to let Ms. Rios or me know if you have questions, okay?
Yes, sir.
All right, Ms. Williams.
Thank you, Judge. Mr. Walker, do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes, ma'am.
Thank you, sir. You may lower your hand.
Mm-hmm.
Could you please state and spell for the record your full legal name?
Larry Lamont Walker, LarryLamontWalker.
Thank you, sir. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given yet today?
No.
How old are you, sir?
45.
And what is the highest level of education you have completed?
12th grade.
Did you graduate from high school?
Yes, sir.
Where'd you go to high school?
Harper Archer High School.
Okay.
Sir, are you therefore able to read, write, and understand the English language?
For the most, yes.
Excellent. Ms. Rios, on behalf of your client, do you waive formal reading of the indictment?
Yes.
Mr. Walker, do you understand that you are currently charged with the following offenses? Count 1, aggravated battery, and count 2, cruelty to children in the first degree?
Yes.
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes.
Have you had enough time to speak with your lawyer, Ms. Rios, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss anything about the case with Ms. Rios?
No.
Are you satisfied with her services?
Yes.
Ms. Rios, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
Yes.
Mr. Walker, have you been arrested on these charges?
Ma'am?
Have you been arrested?
On these charges?
Yes, sir.
Yes.
Okay. Ms. Rios, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
No.
Mr. Walker, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes.
And for the record, count 1, aggravated battery, carries a sentence range of 1 year to 20 years. And count 2, cruelty to children, carries a sentence range of 5 years to 20 years. Sir, do you understand that if you are sentenced as a recidivist under 10, well, actually, I'm reading this, but I have something to add. Do you understand that you are sentenced as a recidivist under OCGA section 17-10-7B or C? You will serve the entire prison portion of that sentence imposed without the possibility of parole, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Your Honor, the state has filed a recidivist notice. However, for the purposes of this plea today, we are willing to withdraw it.
Okay, I'll cover that with Mr. Smith at sentencing time.
Okay. Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state may still recommend a sentence to the court?
Yes.
Are you aware of the state's offer initially of 20 years with 7 to serve?
When you say initially, that's what you're recommending today, or
I'm going to go through everything.
you're going to work through it? Okay.
Were you aware of the state's initial offer of 20 years with 7 to serve?
Today, yes.
Were you aware of the state's secondary offer of 10 years with 3 to serve?
Yes.
Okay. Have you discussed both of those offers with your attorney?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, that Judge McBurney is going to explain to you and already has sort of explained to you about withdrawing your plea and everything like that? Did you understand that?
Yes.
Okay. Do you understand that if your guilty plea is entered and you do not withdraw it, it would be a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that should you receive a conviction in the future, not saying that you will, hopefully you will not, but if you do, that this plea may be used to enhance sentencing on that conviction that applies in Georgia as well as any other state in the US?
I know now, but yes,
Are you currently on probation or parole?
no,
And I'm going to read this just on the possibility that custodial time would be advised by the court. Sir, do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
yes,
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes,
Do you understand that you are not allowed to possess or use a firearm while on probation?
yes,
Are you a US citizen?
yes,
Sir, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm.
yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
yes,
I'm now going to go over the individual rights that you're waiving, sir. Do you understand that you do have the right to plead not guilty?
yes,
Do you understand that if you plead not guilty, this matter could proceed to trial by bench or by jury?
yes,
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses and any assertions of self-defense?
yes,
Do you understand that by pleading guilty, you are giving up each of the following rights? Do you understand that you are giving up the right to trial by jury,
yes,
as well as the right to remain silent and not incriminate yourself,
yes,
and the right to confront witnesses against you,
yes,
and the right to assistance of counsel hired by you or to court-appointed counsel such as Ms. Rios if you cannot afford an attorney at a trial of your case,
yes,
as well as the right to the presumption of innocence,
yes,
as well as the right to testify on your own behalf and to present other evidence,
yes,
as well as the right to subpoena witnesses and compel the production of evidence,
yes,
as well as the right to have the charges against you proved by the state beyond a reasonable doubt.
yes,
And finally, you are also giving up the right to appeal if convicted of these charges after a trial.
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
Is it your decision to plead guilty because you have decided that it is in your best interest to do so?
yes,
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
yes,
Are you asking the court to accept your plea as guilty under offer?
yes,
As to indictment number 25SC007409, how do you plead to count 1, aggravated battery?
guilty, Alpha, under Alpha,
And what is your plea to count 2, cruelty to children? First degree.
guilty under Alpha,
Is this guilty under offered plea freely and voluntarily given with full knowledge of the charges against you?
yes,
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA section 5-6-35. You understand that?
yes,
And do you understand that the appeal that we have just discussed must be filed by your attorney unless you are representing yourself?
yes,
And finally, do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
yes,
Thank you, sir. That concludes all the information and questions that I have for you. Your Honor, the state believes that should this matter proceed to trial, we will be able to prove beyond a reasonable doubt that on October the 4th, 2024, Jeremiah Smith reported to Hutchinson Elementary the social worker there whose name is but the social worker there contacted Atlanta police. Atlanta police reported to the Hutchinson Elementary location and stated that in the report that they were able to speak with Jeremiah at the time. Jeremiah was sent to the social worker because he had lacerations and welts. He reported that he had received those lacerations and welts after he was beaten with an extension cord by his father. We do have, if I can share my screen, we do have photographs from that time.
How old would Jeremiah have been in October of 24?
9 or 10.
10.
Okay.
10.
And I'm just gonna share my screen briefly. Okay. And so crime scene from APD did come out to photograph those injuries.
Same horse side.
And as I mentioned, it was those marks on his arms that initially alerted his teachers to an issue. So once Atlanta police got involved, a detective requested an appointment with the Georgia Center for Child Advocacy. A forensic interview was conducted. It is rather lengthy, so I'll just summarize rather than trying to play clips. Jeremiah did state that his father had beaten him with an extension cord. He stated that when his dad would get angry, he would hit him and with the extension cord, and that was not the first time that he had been scared to tell his mom about it. That some of the healing wounds that we're looking at, the ones that look older, could have been from apparently he was attacked by 2 dogs that were at their home. I have not seen any medical records or anything regarding a dog attack, but I do want to state that Jeremiah did say that in the forensic interview.
Dogs that invaded the home or dogs that adults intentionally brought into the household?
It was my understanding it was their dogs.
Okay.
I could be incorrect, and hopefully Ms. Rios will correct me if I'm wrong. Jeremiah's body language during the forensic interview, he was very withdrawn. He was very quiet. He initially did not want to say what he thought that he might be there for, because the forensic interview is very child-led. So Ms. Lewis, the interviewer, kept saying, what do you think you're here for today? And he really did not want to say. He was shown a picture of his father. He was asked initially at the beginning of the interview what his father's name was, and he did say Larry Walker. And then he began to get more nervous, you could kind of see. And at one point he was shown a picture of his father and he goes, "Oh, no, I messed up my dad's name. His name is Daniel Walker." And I think that was in an attempt to protect his dad. I don't think he was trying to be, do anything wrong, but I think he was trying to protect his father. I did speak with Jeremiah's mom, and my understanding is that as of late, things have been okay. This again occurred in 2024.
When you say things have been okay, is Jeremiah in a household with Mr. Walker now, or?
And I was going to come to that as well, Your Honor.
Okay.
So my understanding is that things have been okay. That, you know, according, in Miss words, that Jeremiah is a normal 11-year-old, and that the interactions in the family have been fine. Given that, however, as I was preparing for today, I did look through Mr. Walker's bond order. And the bond order specifically states that he is not to have contact with Jeremiah, nor is he to have contact with any child under the age of 18.
Okay.
And that was a pre-indictment bond order. So
Right.
that's been in effect for quite some time. So based on the severity of the appearance of the injuries at the time, based on the forensic interview, based on the requirements of the bond order, and based on Mr. Walker's criminal history, the initial offer was 20 serve 7. I was willing, if we had done a negotiated plea, I did make an offer of 10 serve 3. However, at this point, I leave the sentencing in the discretion of the court, given the fact that I am willing to withdraw the recidivist notice.
Okay. Got it.
Thank you, Judge.
Was there anything in particular about what you understand Mr. Walker's criminal history to be that was an item of concern for you, or just that it was significant enough that it was a recidivist notice?
And if anything that I understood about the criminal history is wrong, I do ask that I be corrected. But my understanding is that in the state of Georgia, Mr. Walker has 19 cycles. After the case that we're here for today, Mr. Walker was arrested in January of 2025 in Chamblee with a firearm in his possession. He is also on the sex offender registry, and he is classified at a level 2, which means he is not even eligible to apply to be taken off the registry yet, based on a 2009 conviction for child molestation in Fulton County, and I do have that case number. And in that case, he was given 15 years probation. Based on my review of Mr. Walker's record, at any one time, he has not served longer than 1 year. So, and he also has some probation violations. So, recommendation of straight probation did not seem appropriate. A recommendation of time in custody of less than 1 year did not seem appropriate, given this.
Okay. I appreciate that.
Thanks, Judge.
Anything from pretrial that differs from what I heard from Ms. Williams?
I mean, you got 01, 02, possession of a firearm, possession of a firearm by convicted felon conviction.
Okay.
Intent to commit armed robbery, assault,
Any information that you were able to find that talks about a disposition for the 2025 arrest in Chamblee for once again having a gun? So it's just open. Okay. All right. Thank you. Ms. Rios.
Yes, Your Honor. Mr. Walker is 45 years old. He has 7 children. He's currently a shift manager at Bojangles. I understood, I didn't have an offer before today. So I was trying to talk to Mr. Walker and his wife, and she's the mother of the child she's here today. The DFACS records have been closed. They have stated that the child is fine to be in the home. And so for the last few years, they've just been fine. He's been working, taking care of the children financially, doing his responsibilities. They did have a dog. The dog left bark marks. They were showing me their marks from the dog. And they ended up getting rid of the dog because of the dog's, I guess, aggression issues. And that's and even when you look at the pictures, to me, they look more like bite marks from a dog or scratches from a dog. But they may have left it going on too long. They've all been scratched up and they finally got rid of the dog. With this case, Your Honor, he is maintaining that that's why he's doing an Alfred plea, that those scars were not from him. His mom has said that that's not what happened. I'm not sure how that would go at trial. I understand what the child said initially. She does want to speak on his behalf and say a few words in support of Mr. Walker, I'm asking for the sentence to be for both counts, 10 years probation. If you're not inclined to straight probation, 6 months, weekend jail, so he can still maintain his job. He has several children. 6 of the 7 children are underage that he is providing financially for. She relies on his support financially. She was just outside having a breakdown because this is going to be hard for her to take care of financially all her kids by herself. Did you want to say anything in support?
Can we take the exhibit down, please?
Let me stop sharing. Hold on just a second.
It's gone.
Is it gone? Okay.
Yeah. Okay. It's afternoon now. Good afternoon.
Good afternoon.
You are
Shakita Smith.
Miss Smith.
I'm sorry, Shakita Walker.
Ms. Walker.
Yes.
Okay. And your connection to Jeremiah is
I'm
your
his biological mother.
biological mother.
Yes, Your Honor.
Okay. And is Mr. Walker the biological father?
That I don't know. Like I told the lawyer, like we've been on and off. So
Okay.
you know, at the end of the day, a woman don't know if they're pregnant until what, about 6 weeks. So
I trust you on that.
at the same time, like, you know, I didn't know I was pregnant with now one of my kids because we was on and off. So
Okay.
I don't know who my baby's father is, but I know he's been there since
Okay.
day one. So
Who else is in court today?
that's my son. That's my oldest son.
Your oldest or your youngest?
My oldest.
How old is he?
He's 17.
Okay, but that's not Jeremiah.
No, that's not Jeremiah.
I'm not asking you, Mr. Walker, okay?
Yes, sir.
So that's one of your kids.
Yes, that's my oldest son.
Got it. And you have 7 kids?
I have 5 that I birthed.
Okay, and then there are 2 more that stay with you?
No, them are
They're
his.
Mr. Walker's kids?
Yes.
Are they older than your kids or they're in the middle?
Well, he got a son that's I want to say 15.
Mhm.
So he's at the same age as my other 15-year-old, and he got a daughter that's 23 or 24.
Okay, and that daughter stays with you also?
No, Your Honor.
She's on her own?
Yeah, she got her own apartment.
Okay, got it. But you still have a pretty full house with all those kids?
Yes, I do.
How young is the youngest?
He's 11 years old.
11, okay. But that's not Jeremiah. He's not the youngest?
No, Jeremiah is the youngest.
He is the youngest. So the youngest is Jeremiah, and then you've got a 17-year-old and a bunch sandwiched in between.
Mm-hmm.
Okay. Are they all in school?
Yes, Your Honor.
Where do they go to school?
My oldest 3, they go to Tri-City High School. And then Jeremiah and Darlene, they go to Paul D. West Middle School.
Got it. And then they'll be at Tri-Cities when they're the right age.
Mm-hmm.
Okay. All right. Do you work outside the home or you're pretty much in charge of making sure the house doesn't fall apart?
Well, I don't have to go to work till 12 o'clock at midnight. Yeah.
Okay. You have a midnight shift. What do you do?
I do security.
Okay. How many nights a week?
It's 6.
Okay. What time do you get home?
I get home at 4 o'clock in the morning.
Oh, so it's a short shift. It's just a tough, meaning
On the
it's,
week, like on a Saturday, I go in from 9 p.m. to 5 a.m.
Got
So
it.
that's like a long day for me on the weekends. But, you know,
like on a
Mondays,
Tuesday, it might be
it's 12 to 4.
12 to 4. Oof. Okay. So you're actually home before the kids need to get up to go to school.
And I leave before, you know, they go to bed. So everybody be in the bed prior to me leaving.
Got it. They're in bed and then you go off to work. Okay. Got it. Was there something you wanted to tell me about this situation or what should happen with Mr. Walker?
I'm gonna be completely honest with you, Your Honor. Like, I mean, I got 5 kids that's at home. You know, I'm the only one that's working if he's not there. And, you know, I do have rent, I have bills. All our money put together, we can make that. But me just being there by myself, it's not gonna work. I will lose my house. And then 2, I'll lose my kids to defects because I don't have nowhere to go. Or, you know, anything like that. So, and that's, you know, I talked to Miss Williams yesterday over the phone because she called me yesterday. So I did talk to her. You know, we did talk. And I was basically like, you know, the parenting classes, anger management, you know, like that's what me and Miss Williams had discussed. And so.
You've mentioned that Mr. Walker is around sometimes, he's not around. Tell me what you mean by that, that he'll stay with you for a while and then he decides he's gonna go be Mr. Walker somewhere else?
I wish he would, but no. No, Your Honor. What I mean by that is that, he works as well. So, if he basically, get jail time or anything like that, and he's not there to basically help accumulate the money with me, then yeah, that's what I was talking about. I wasn't talking about him doing anything else.
Well, I guess I thought when you were describing, you weren't quite sure who dad was for your kids.
Oh, yeah.
And that Mr. Walker was sometimes present in your life and sometimes not. So not that he would go to work, but that it might be that because you guys have a disagreement or he just has another situation going on that he might for 2-3 weeks be somewhere else.
Now, we did have that issue because like I said, both of our sons actually the same age. They're 15 years old. So both of them the same age. It's just a year apart from each other. So in that time, our relationship was just on and off. Like, if he didn't want to do what I say or if I didn't want to do what he say, then we'll break up. But see, that's the thing. I wouldn't know I was pregnant until, about probably like some months later. And then, I reach out to him because like, hey, you're the last person I talked to, so.
Okay, but that's your 15-year-olds. Jeremiah's only 11. So for those 4 years, he sometimes was in your life and sometimes not in your life.
Yep.
How is it now?
I mean, we live together. We do. We live together. And, he's always been there.
Okay. Whose job allows for more money to be contributed to the household?
Well, he get paid every week. So it's his job. I get paid every 2 weeks.
Okay.
So.
But is your 2-week paycheck bigger than 2 weeks of his work, or who is it who's able to contribute more?
Well, he's able to contribute more because, like I said, I only work from 12 to 4. So that's really only
Just few hours.
hours. Yeah, and my long day is on a Saturday from 9 to 5. So
Okay.
that's not really any type of money to take care of a rent. That's, $1,500, water, gas, lights.
Mr. Walker is able to work more hours. What are his hours?
Well, he go in from in the morning? 9 in the morning to around like 4 in the afternoon. So, I mean, I'm still at home around that time because I don't have to leave till 12 o'clock at night.
Right. Okay. All right. Anything else?
No, Your Honor.
All right. I appreciate you being here. I appreciate the tricky situation you're in. I think you can understand I want to support your household, but I also want someone like Jeremiah to be safe. And I'll tell you now, because Mr. Walker's going to hear it from me, I've had dogs my whole life, and dogs don't make marks like I saw on Jeremiah's arms. So that wasn't a dog thing.
Now, I can attest to that. Now, I don't know what happened with these puppies. I really don't, because they pit bulls. I know half of them was dying due to Provo. The other one, yes. The other ones, they was more like on the sickly, weakly side. So I kind of went to the feed store, which is actually on Candler Road in Gresham and Candler. So we went to the feed store to basically try to get something for them to keep them going. But apparently, I don't know what happened. I don't know how they went rogue, but they did. They went rogue. So.
How long did you have the puppies?
They weren't even, I want to say about 6 months, about 6 months.
Okay. Well, I appreciate you being here and doing what you do to support your household.
Do I see bedtime? Oh.
Ms. Rios, anything else on behalf of Mr. Walker? Mr. Walker, anything you want to add?
Yes, I actually do. It's to listen that I raised my kids who I've been around. Me and her been in the beginning off and on, but for the last few years, we've been really solid. I've been on, yes, I got priors, and they the one who kept me out of trouble. My kids, they kept me out of trouble. So, and to hear my son on that camera getting tapped by these little puppies about 6 to 8 months old, I'm up there doing everything I can because I was working in Duluth. I took on another extra shift in Duluth, Georgia. I was on the camera trying to definitely get these dogs off on. We have a grown dog named Princess. I was like, Jerry, get in, open the door because Princess, she very protective of the kids, very. So I asked him to get to the door to open the door, let Princess out so she could defend you. She finally did that after some time. He finally did that. What I was trying to explain to the case defects worker, if we have blink, it only stayed. We actually had the recording, but it only stayed for so long. I love my babies. I ain't never hurt my babies. They each and every last one on tell with no coerce, no nothing. They'll sit them down. They'll tell you. They'll tell you. And the main thing I teach them, who you come in this world is, that's who they gonna, no matter what, ain't gonna like you. The second red strike you'll have against you is lack of knowledge. And every last one of them will testify to that. You know, I know these some serious charges I would never play with. I know these serious charges. But at the same time, y'all, I don't beat my children with stench cord. I wasn't raised like that. My mom, one thing she told me, a man's voice would do more justice than anything. And that's what I live by. If she could wake them up in the morning, they'll be rolling over like this. I say, get up. They'll get on up. You know,
What happens if they don't get on up when you say that?
First, I'm not, you know, I'm human. I'm going first. I don't want my kid to be part of the society, what's going on. I want them to be fine young men and ladies. That's why I took my lesson in being in the system and talk and giving. That's why I asked, that's why I made sure he came. Because he's 17, he's gonna be 18. When he turned 17, I didn't tell him first, happy birthday. I told him, you go out there with nothing, you mess up, you old enough to go to jail. So I try my best. I'm not the perfect father. I'm not gonna lie, I never will. But I do try to follow by the guidelines. It's tough, it is. And that's no excuse, because they didn't ask to be here. And that, but I'm taking on my responsibility. And I love every minute of it. He come out of school next year. I got one behind and one behind. I would love to join and see that. They give me joy. We just had, like my Jeremiah and his sister and the other brother, they with our pastor in Chicago. My kids is everything to me. They the one keep me afloat. They does. Especially that's my replacement. Cause no matter what happened to me, he gonna feel, he gonna take over it. So like I said, I'm sorry. I'm sorry. Cause what they brought out, and they didn't even investigate, and nobody even really wanted to sit there, take their time investigate. Them dogs almost killed my baby. Them dogs almost killed my baby. They didn't even take my wife and the rest of them. We got the same marks. We have the same marks. I know you see and hear everything, a lot of stuff, but I'm trying to hold back these here because these my babies. I've been there, regardless biological or not. I've been there, rocking them in they seat with the bottle, everything. I've been doing that. She been, well, both of us, and we recently did get married because we've been together too long not to be a unit. So she told me, like, it wasn't no like an ultimatum, but we were like, come on, we've been together too long. My son about to be a real adult. So that's all I have, y'all.
How many times did you let the puppies attack your kids before you decided to get the puppies out of the house?
They attacked us first.
How many times did you let them attack you before you took them out of the house so they wouldn't attack your kids?
Okay, they was in the house. The puppy was in the house. Cause like she said, they were sick. So they started feeling better. So that's why we actually had them in the house. Cause they had problem. So we were trying to keep them alive. So we did try to reach out to Fulton County Animal Control. We tried to have them, but they tell us they couldn't do that. They couldn't come get them. And I'm like, why? We offering you to get the puppies. They didn't never want to come out there and get them. So we kept the puppies. One day we came home, she walked in front of me. When she walked in front of me to put the key in, and when we pushed the door, it swung open. It somehow alerted the dogs, and the dogs just went crazy. So we had to fight them then. So after that, I said, no, they got to go outside. So we actually went to Walmart and bought some kennels and had them outside. When they was outside, we had a big look like a, kennel, like a big old kennel. So we took them outside and we had them outside. What happened with Jerry was, Anthony was at home at that time. So when they was in the house, somehow they got in the house with Jerry and Ant-Man. And it went berserk up. And the day they attacked Jerry, I think we separate the puppies because it seemed like one would start and it'll make all of them, fall in slime. So we kept the two outside, we put two inside. When Jerry got home, the puppies somehow got out the little plastic kennels that we had. And they were roughing my son up. After that, when I seen that, and I was looking at that door and the cameras on the blink, they got to go. They got to go. I understood when it was us because we were grown, we came in that door loud, and they was, just getting over sickness. But when they tapped my baby, no, she'll tell you what I tried to do with one though.
Probably don't need to tell me that.
Yeah.
Okay. Anything else you want to share?
No, sir. I just honestly, I know, like I said, I won't nobody play about these charges. But my truth, I don't hurt my kids. I never did, never will. This is, I raised them. Let me start saying me. We raised these kids together, and it's through thick and thin. That's all I got. I'm not trying to. So.
Okay. Well, Mr. Walker, I don't want to go a whole lot further. If you're not interested in a sentence that involves you going into custody, I don't see imposing a sentence that doesn't involve you going into custody. So it may be that you want to just move this to the trial calendar, and we're going to need to let a jury sort out the dogs did it versus, I don't know why he'd make it up, that it was an extension cord. But the injuries I saw, along with some of what you shared with me, I don't see, I'm not imposing a sentence that's just probation. But I appreciate in particular why Ms. Smith needs you around. And there are people who, I don't think you did it intentionally, but you've built up a dependency. They need your income to keep the household afloat. So it may be that you're not interested in pleading to something that results in you going to prison for a while. You got to leave it up to the jury. And if a jury buys the dogs did it story, they find you not guilty, then you don't need to worry about it. But the jury will be looking at the pictures of Jeremiah's arms and his legs, and you'll have what defense you have. They'll see the statement he gave at the forensic interview, and they'll need to decide what they're going to do. Yes, sir.
Oh, I ain't mean it.
No, I can pick up where I left off.
but on the pictures that we saw sent to our lawyer, like it actually shows where the doctors were like, they were saying that they couldn't, like, they were like, it's not, the remarks that they made, it don't support the extension cord and stuff like that. That's all I got.
Okay, and you may be right, and that's the kind of thing that Ms. Rios will be sharing with Ms. Williams, and it may be that between now and trial, the state comes back with a different recommendation. But based on what I've seen and heard, I'm not going to be imposing a sentence that is just probation. But I also understand why you would say no thank you to a sentence that involves you going into custody for a whole bunch of reasons. The number one being your family. But even if you didn't have a family, who wants to go into custody? So it was an offered plea, and I'm assuming you don't want to go forward with me forecasting that if I impose a sentence, it's going to involve you going to prison. And you'd rather have this case move on to the trial calendar. Is that a fair statement? Okay, so it was helpful that we had this discussion. I got to learn more about you. It was particularly helpful to hear from Ms. Smith because she helps paint a picture beyond your criminal history and what these allegations are. Those are important things for me to hear. As I promised you at the beginning, it's as if this didn't happen. The state doesn't get to tell the jury, oh, he almost pled guilty. That doesn't come up. If this goes to trial, it will be about what happened in October of 24. And it sounds like there's a lot for Ms. Rios to work with the dog scenario, and maybe medical professionals saying, I've never seen an extension cord make a wound like this. The doctors are gonna say what they say. The one thing you need to understand before you say no thank you, two things that change after today. After today, if you do decide to enter a plea because you don't want to put Jeremiah through a trial or whatever your motivation is for entering a plea, you don't get to withdraw it if you don't like the sentence you get. So if I do the 10 serve 3 or something that I think is a little different, that's your sentence. No, you don't get to hand it back because you don't like it. The other thing that changes is that the state's offer expires. They may renew it, they may not. And what I heard Ms. Williams say, and she'll confirm it in a minute, is that for today, she was withdrawing the recidivist notice. And that has this most important impact. Whatever amount of prison time I sentence you to, as a non-recidivist, in other words, with the notice withdrawn, you're parole eligible. So if I were to say 3 years, you might get out after a year or a year and a half. You'd be parole eligible. If you are sentenced as a recidivist, whatever amount of time I sentence you to is non-parolable. So if we go with the 3, it would be 3 years to the door. Now you get credit for you spent 31 days in jail back then. You get credit for that, but it's effectively 3 years to the door. So that may change because Ms. Williams said for today, I'll withdraw the recidivist notice. But that says to me in the future, certainly if you go to trial, that recidivist notice will be in place. It just means that then whatever sentence you get, there's not a parole element to it. Do you understand that?
Yes, sir.
Okay. I figured you did because I know you guys have been talking about it. You, Mr. Walker, are on... Where'd that email go? You are on the trial calendar at the end of May. So you don't need to be back here till May 28th. You'll get notice of that. Ms. Rios will be talking with you about it. But you'll need to be here on that date we call the calendar. If between now and then, Ms. Rios and Ms. Williams and you sort something out, we can have that conversation before then. We don't need to wait that long. But if the state's offer doesn't change and you're not interested in their offer, just know then that we'll be getting set for trial at the end of May. Okay? Ms. Rios, anything else on behalf of Mr. Walker?
No, Your Honor, thank you.
Okay, Ms. Williams?
No, Your Honor.
All right, we do need to deal with this fact. Mr. Walker's bond says stay away from Jeremiah Smith. And in violation of that bond order, you've been living at home. I make it sound worse than it is. You've been living at home with the woman you love and the kids you take care of. But unless we work through modifying that bond, Jeremiah needs to get out or you can't be at home.
I
And
can't be at home.
I'm not gonna make Jeremiah move.
No children under the age of 18 as well.
Yeah, well, I didn't see that in the,
All the way at the bottom in the fine print. That's why I didn't see it initially either. There's a small,
I'm not disagreeing with you, I'm just trying to find it. It does say, it references the molestation conviction. Oh, this is the bond denial. It's odd, it says stay away from Jeremiah, but it denied your bond. Let me find where you got a bond. Okay, here's your bond, different judge, Judge Brooks. And yes, it is not in small print. It's the same size as everything else. No contact with any child under the age of 18. And are you wearing an ankle monitor?
Yes, sir.
Oh, okay. Is the county paying for that? You're paying for the ankle monitor?
No, not the bond.
Not the bond, but there's a monthly fee for the ankle monitor.
I get there at the county.
You're not having to pay for the ankle monitor?
No, sir.
Okay. Okay, way up at the top. We're paying for the ankle monitor. You had to pay for the bond. You've taken care of the bond. But Judge Brooks said in November of 24 that you could not have contact with any child under the age of 18, which is all of your children except your daughter. So we either need to have that amended or you need to, between now and the start of trial, not stay at home.
I got another address on.
Well, are you going to be in a position to still support the household?
Yes, sir.
Okay.
Yes, sir. This is my sister. Yes, sir.
All right. Ms. Rios, you should engage with Ms. Williams to see if there's any interest on the state side to modify that bond condition in light of how Mr. Walker's lived the last year and a half anyway. And I'm open to considering that if both sides want to do that.
Yes, sir. Thank you.
Okay. So it is fine to go home today to get some stuff, but Judge Brooks ordered that you not have contact with children under 18.
Yes,
so you can go home with, is this Ant-Man?
Yes, sir.
Okay, with Anthony. But tonight you got to be at your sister's until Ms. Rios can either persuade the state to move to amend that or something else.
Yes, sir.
All right. Anything else, Ms. Williams?
no, you're wrong.
All right. Thank you, everyone.
Thank you.
The Trapper Keeper?
Yeah, I see one behind.
I remember some podcast, they interviewed the inventor of the Trapper Keeper. Yeah, guy made a ton of money.
Yeah.
Wow.
It was, the parents are the ones who loved it because it sealed it up so kids wouldn't lose their papers. And then once you could put Barbie or whatever on it, it's like, the kids will want it because it's got the cool logos. Okay, we can get started now. I just need to be able to hear you. So if you are more comfortable standing, that's fine. If you want to be seated, I can certainly hear you and we'll do it that way. Are you with MARTA per se, or are you a firm hired by MARTA?
With MARTA.
Okay, in-house counsel.
Yes, the associate counsel for MARTA.
Okay, I had been working with Ms. Lewis. So is she still at MARTA?
She is, so actually she has been promoted.
Oh, congratulations to her.
So I,
Are you the new Ms. Lewis?
not quite.
Okay.
Not quite, not yet.
Okay, well, great. So it's still in-house with MARTA, and you're going to explain why you think the appeal should be dismissed.
Correct.
Okay.
So, as of what I have in, based upon the docket, my colleague, now superior, attorney Lewis filed this motion to dismiss on October 8th, 2025. The main contention is that Mr. Pope, though he did file the notice to appeal initially on May 13th, on May 23rd, 2025, approximately 10 days after the judgment, he did not cause to be attached or file the transcript after requesting that the transcript be included. Per his initial notice of appeal filed on May 23rd, 2025, he did specifically request that. He also requested the inclusion of the transcript in his subsequent amended notices of appeal. Just to clear the timeline before applying the relevant law, on July 30th, on May 27th, 2025, Mr. Hope also included a request for evidence and request for the record. And then on July 30th, 2025, he filed his first amended notice of appeal. And then on August 6th, 2025, he filed a second amended notice of appeal. However, at no point within the 30-day period did Mr. Pope file for or apply for an extension as required by law. Without him filing for that extension timely, the failure to include the transcript does fall on him.
And the extension would be filed with the Court of Appeals saying, give me more time, or it would be filed here saying, Judge, I need more time to assemble the record that I want to have sent up, because he's defined the contours of the record. He could have said, I don't need the transcript, I just want the briefs or whatever, but he very understandably said, I want the transcript to be part of the record. And because he defined it that way, there's a burden on Mr. Pope to then assemble that record.
Correct. Yes, for the most part, for certain things that are not already on record, specifically for the transcripts. And the reason for that being, well, let me answer your first question. That request, if he did file an extension, it would have been filed with the trial court, so it would have been filed here, and that's under OCGA 5639. So sticking with that statute, that extension that Mr. Pope should have asked for or would have timely asked for would have to have been made before the expiration of the period for filing as originally prescribed, which would have been during that 30-day period. Going further, because this appeal comes from a civil trial, the court reporter would have only been required to file that transcript had the transcript actually been ordered. So that it was not mandated that the trial record or the proceeding be transcribed. So there is a difference there between the takedown and the transcription. And I think the issue here is that the proceeding was taken down. However, MARTA did pay the full cost for that particular court reporter. And because MARTA didn't have a need to have it transcribed, it was not ordered. So at that point, and also under, Georgia code, any appellant who wants the transcript to be included in the notice of appeal in the record to be, transferred to the Court of Appeals has the responsibility to obtain that transcript. And just for further support, I believe there is an on-point case which has very similar, almost not the same facts as we're dealing with here. So specifically, and also according to the record, I have noticed that Mr. Pope has now filed a, notice of extension or a request for extension, well, was filed in January of 2026, which Marta still contends that is untimely. But according to some of the filings by Mr. Pope, he stated that, it was on the court reporter to make sure that the transcript was filed, and also he was unable to procure the transcript from the court reporter. But that is actually still, according to the law, that would still fall on him. And the case that I'm referring to or using as support is Dampier versus First Bank and Trust Company, where the appellant did not apply for an extension timely. And though the notice of appeal was timely filed, the appellant was not able to get the transcript from the court reporter within the requisite time. And the court did hold that that was unreasonable delay caused by the appellant.
What is the citation for Dampier?
Yes, so that is 153 Georgia App 756.
All right. Okay. Anything else?
That is all for him.
All right. Thank you. Mr. Pope, what are your thoughts about how I ought to handle this?
First I'd like to speak about my case and time frame between when you issued your verdict and the time I filed an appeal and what took so long. I'd like to speak about that first.
Okay. Well, you filed your notice of appeal timely. That wasn't late. So I entered the final judgment on May 14th. You filed your notice of appeal on May 23rd. I don't think Marta's fussing about that because that wasn't late. It's what happened after that and why now, almost a year later, 11 months later, the record hasn't been transmitted to the Court of Appeals yet. So you should talk about what happened after you filed your notice of appeal.
Okay, fine. All right. On May 14th, 2025, I emailed Ms. Lewis and inquired about the transcript. And I'd like to read that. I said, I would like a copy of my case transcript. Can you please provide the name and number of the private court reporter who were in attendance on May 12th and May 13th? Thanks. I didn't get no response. I tried again with Ms. Lewis on May 19th, 2025. Good morning, Ms. Lewis. This is my second attempt in trying to communicate with you in good faith. I would like a copy of our trial transcript. Can you please provide me with the name and number of the private court reporter that was in attendance on May 12th, May 13th? Ms. Lewis, as a certified attorney, you have an ethical obligation to uphold. Please abide and thanks. Have a great day. I didn't get no response. Then tried again on May 21, 2025. Good morning, Council Lewis. I'm reaching out to you requesting permission to split the takedown fees for May 13, 2025 trial day. I would like to pay my portion of the takedown fees to obtain a copy of my trial transcript. Are you in agreement with the splitting the takedown fees? Thank you in advance for your prompt response. Then I noticed, I heard her say that Martin didn't pay the court reporter for the whole, I guess the whole portion of the transcript. But Ms. Lewis said that she emailed me back and said that she can't, she won't allow me to pay my portion of the takedown fees, and that Martin had already paid the whole portion of the.
Right. So takedown and transcript are two different things. Takedown is the cost to whoever pays it for the court reporter to be there and, like it sounds, take it down. That's not a transcript, but that's what Marta paid for. And it sounds like Marta said, we're not going to split it. We've already paid that. But you mentioned that Ms. Lewis wrote you back. When she wrote you back, did she tell you, by the way, the court reporter was Sally Jones with Smith Court Reporting? She told you who the court reporter was.
So I think I got the court reporter from
Galo, actually I called.
Well, I didn't ask that well. When was it, please give me the date, that Ms. Lewis told you what the court reporting company was? Because you just mentioned it, Gallo Court Reporting. You didn't invent that, so she must have told you. When did she tell you that was the company?
I don't know the exact date, sir, but she did email me, but I don't have that. With me the exact date that she told me.
Well, would it have still been in May? Because if she's already talking to you about splitting the cost of takedown, she must have given you the name. What's the date of that email?
On August 29th, I emailed Galo Billing requesting the name of the court reporter. So, Ms. Lewis, and this is in August,
Okay.
please advise the name of the court reporter for the case 2023CV386362, and also the status of filing a transcript with the court report. Trial was on May 12th and the 13th of 2025. Can you please give me an update?
This is you to Gallo or you to Ms. Lewis?
Gallo.
And that was in August?
That was in August.
Okay.
And
Well, that doesn't answer my question about when you learned that Gallo was the company that did the takedown.
I'm pretty sure it's in my email, sir. I don't have,
Okay.
Ms. Lewis' email sent back to me right now.
Okay, keep going.
Okay. And Gallo sent back an email on August 29th, 2025, and they said, "Good afternoon. We only covered the trial that took place on May 13th, 2025 before the Honorable Judge Robert C.I. McBurney."
Well, I just got the answer because you ended up including my staff. On May 21st, so actually before you filed your notice of appeal, Ms. Lewis let you know that it was Gallo Court Reporting. What else do you have?
I had to go undergo surgery in August 11th, and I was out for 3 months. I returned back to work December 1st.
Are you still with Marta?
Yes,
What are you doing with Marta now?
and real outlet.
Okay.
So that's why I was, I had fell behind on bills, and I wasn't working. So between 8/11 and December 1st, I started back to work December 1st.
You didn't get FMLA or whatever it would be called, sick leave, because you were out because of surgery?
Oh, no, I was on the workers' comp.
So you were getting workers' comp?
Yeah, but workers' comp, there's no money. My normal, they don't cover anything. My normal work hours is 8 hours a week. Workers' comp only pay 2/3 of the salary. So I requested I filed an extension in January.
I thought you said you're back at work. Are you not back at work?
Yes, I'm back at work.
Okay. Oh, you filed the extension, yes, in this, correct.
I filed an extension, yes, because
Yep.
I needed more time to, get the, cash to purchase a transcript.
What does it cost?
I think she said like 1,700, and she said that, and it may be even more than that. And, other things that come with it. So that was my reason for, needing more time.
Okay, got it. But you're back at work. That's good news.
Yes, I'm back at work.
Okay.
And I have, my medical documents to, prove that I was out.
Okay. All right. Anything else? Ms. Scaife, as the movement, anything you want to say in response to what you heard from Mr. Pope?
I would just like to reiterate that the law is the law, and while I do understand sometimes that things happen to us that can kind of like prevent us from doing things the way we had anticipated, when we decide to pursue something like this, even if we are pro se, we are still held to a certain standard. And given the fact that he was able to file the notice of appeal timely and had the wherewithal and the ability to determine that he needed to include the transcript, there is no reason for not being able to either timely attach the transcript or at least file for an extension within the requisite time. And so for that reason, and provide the support in Georgia case law and the Georgia code, we would just like to again ask that this be dismissed.
Okay, thank you. All right, well, I will take this under advisement. It was helpful to hear from both sides, and I will get an order out soon. Anything else we need to cover from Marta's side?
I'm not sure. I know that there was an order on attorney's fees for the underlying case. I did see that Mr. Pope did file a response to that. But I'm not sure that there has been any payment to Marta for those fees. But I would understand why not, given what Mr. Pope has just explained to the court.
Let me look here. I entered an order, March 24th. So we're a few weeks in. But I guess now that you filed your entry, you'll be the one engaging with Mr. Pope about his obligation under that order. And if he doesn't meet it, you know how to find me. We can always get back together. All right? You bet. Mr. Pope, anything else on your behalf?
Yes, I like to read OCGA 5638 requires the prospective appellant to file a notice of appeal within 30 days of the final order and cause the designated transcript of evidence and proceedings to be transferred to the Court of Appeal. Trial court has authority to sanction parties not complying with the deadlines and diligence required when filing an appeal OCGA 5648. OCGA 5648 provides the following. No appeal shall be dismissed by the appellate court with no consideration of any care therein refused because of failure of any party to cause the transcript of evidence and proceedings to be filed within the time allowed by law for order of court. But the trial court may, after notice and opportunity for hearing, order that the appeal be dismissed where there has been an unreasonable delay in the filing of the transcript, and it is shown that the delay was inexcusable and was caused by such party.
That's right. That's what I'm looking at it. 5648C. That's what it says.
I don't think I have a, inexcusable delay, inexcusable reason as to why. I can possess the transcript,
You have provided an explanation, and I need to decide whether that is an adequate explanation under the law. So I follow what you had to say. I follow what Ms. Scaife had to say, and now I gotta weigh both those and figure out where I land. All right?
Yes, sir.
Okay. Well, thank you, everyone. If I have questions as I'm thinking through it, I'll make sure that the email goes out to both of you, even if it's a question to just one side, so you know what it is I'm curious about. And we'll go from there. You guys have a good weekend.
Yeah. No.
John, can you hear me? Never mind.
All right, good afternoon, everyone. We have a civil default and status calendar. There were 4 positions on it. Position number 1 has been continued. So if anyone is on for diverse staffing versus we packet, you can go home, start your weekend early. Position 2 is Pine Tree Condominium Association versus Amerigo Tires. Mr. Denhart, I think that's your case.
Yeah, correct, Your Honor.
All right, let me get you on the screen here. There you are. Anyone here for Amerigo Tires? You're here for Amerigo Tires. You are?
Sean.
Are you Sean Williams? All right, Mr. Williams, why don't you come pick one of the seats in front of a screen there so Mr. Denhart can see you. In fact, that's the one with the screen, with the camera on. So if you'd sit at that table, please, right in the middle of the table. All right. So where we are, as I understand it, and Mr. Williams, I'll hear from you each time. I'm going to start with Mr. Denhart each time because he represents the plaintiff. You technically don't represent Amerigo Tires unless you're a lawyer. And if you're a lawyer, then you're all set. But if you're not, in Georgia, limited liability corporations can only be represented by attorneys. So I'll still hear what you have to say, but it's not the official word of Amerigo Tires. The company's actually in default, but we'll walk through that, okay? All right, so as I understand it, Mr. Denhart, your client is seeking the standard array of relief. In a case like this, it would be damages in the sense of unpaid assessments, a foreclosure, so that when the property is sold, that's the way you can recoup the amounts that are owed, and then attorney's fees, all connected to a failure to pay assessments. Is that a fair summary?
Correct, Your Honor. That's a fair summary.
Okay. And at some point during the litigation, Mr. Williams, you filed something in the docket. We didn't know about it because dropping it in the docket doesn't mean it lands on my desk. But you filed a few things, again, as Sean Williams, but not as the lawyer for Amerigo. So I'm happy to hear you out a little bit, but because Amerigo Tires did not timely answer the properly served complaint in this case, it's in what we call default, which means Amerigo Tires has admitted all the allegations in the complaint that Pine Tree Condominium Association set forth. That's legally where we are. And that may frustrate you, but you needed to have a lawyer speak for Amerigo Tires. Tell me what you want to tell me about the situation.
Oh, no, I had no problem with the fees. My problem was not the fees. I didn't have a problem paying the association. The fees was overwhelming. It was just too much fees to be paid.
When you say fees, are you talking about the monthly assessments?
No, not the monthly assessments. And then it was conflicted because I would get different invoices in. You owe 5,000, you owe 2,000. It was just over there. And I tried to remedy it by sending out $4,200 and something, and it didn't accept it. It came back to me, without it being accepted, and I paid for the water bill and paid it off, and that was even added on to the amount. That's over.
So in the complaint, it said that you had a principal owing of a little more than $7,000. And that's made up of all sorts of things. It's attachment. Oh, we've got the articles first. So we got to scroll through here, but there is a ledger that sets forth what the assessments are. They're all there and they add up to the 7,135. So what's going to happen today? And you did get credit in October. I say you, Amerigo Tire. There was a payment of 3,150, so they accepted that. So I don't know when you tried to pay the 4,000, but what I don't want to do is go around too much in a circle with you, because what's going to flow from today, after I talked to Mr. Denhart about one question I have, is it's going to be a judgment in favor of Pine Tree. They have a number of tools at their disposal once they get that judgment, but that does not preclude you from getting together with Mr. Denhart as counsel for Pine Tree to say, what do I need to give you right now to make this go away? And if his client, the condo association, decides, you know what, we just soon keep this guy here, it's cheaper than doing a foreclosure and this and that, we'll take it, then you're all set. But what you're not able to do, unfortunately for you and Amerigo, is parachute in now and say, I'm Sean Williams, you got to listen to me, Judge, even though I'm not the lawyer for Amerigo. You may be right about all the things you're saying, about you tried to send them money and they rejected it, although they're free to do that once things get a little beyond late. But you will still have the ability to reach out either to counsel to Pine Tree, or there may be someone from the association that you deal with to say, you know what, my bad, I fell behind. What do you need to make it work? And sometimes they'll say, we need everything up front. Sometimes they'll agree to a payment plan. You know what, we want a big chunk up front, and then along with the monthly fees, the $300 assessment, you're going to need to put in an extra, I'll make it up, $250 until you catch up. I see those resolutions all the time. But that's a conversation that'll happen between you and either Mr. Denhart, or he may say, you need to call Jane Smith from the association and see what they're willing to do. Okay? Mr. Denhart, I'm going to turn back to you with my one question. In your motion for default judgment, I want to make sure I'm specific here. And where's the complaint? The address is slightly different. There's 2105 Pine Tree Trail. That's your complaint. In your motion for default, nope, that's the same number. It must be somewhere else in there. The addresses didn't quite line up, and I just want to make sure that the final order reflects whatever the correct address is.
Yes, Your Honor. The correct address is 2105 Pine Tree Trail for this unit.
Okay. Good. And then I guess there's another address, but this is in the complaint, and it's a Cheshire Bridge Road, but that is the way you serve Amerigo Tires through its member, meaning the owner of the LLC, Mr. Williams.
That's correct, Your Honor. The
Okay.
registered agent is not maintained for the corporation.
Pardon me?
The registered agent was not there, so we served through a member.
Yeah. Okay. All right. Everything else was in order. Do you have a proposed order that you can get to Ms. Niles?
Yes, Your Honor.
Okay. Let me check though. We have. That's not it. Position 2. No, okay, those are just your exhibits. So, yeah, if you could get a proposed order to Ms. Niles, what is the answer for Mr. Williams? If Mr. Williams is eager and sincere about trying to come up with a payment plan or just a full, here you go, let's sort this out. Should he reach out to you, or do you have someone from your client that he should contact?
Miriam Webb from Pine Tree Condominium Association.
Is that a name you're familiar with, Ms. Webb?
Yes.
Okay, and she would know what the balance is, and she would be empowered if Mr. Williams were to say, I can't give you $7,000 right now. I could give you 5, and then could we do a payment plan? Ms. Webb has the ability to discuss that with Mr. Williams?
Correct, Your Honor. She has the authority to do so on behalf of the corporation.
Okay. You know who we're talking about? That's who you should reach out to, because Mr. Denhart is going to be letting Ms. Webb know, hey, you're about to get a judgment that enables you to foreclose on the property if that's what you want to do. That's always a last resort because it's complicated to do a courthouse sale and there's lots of paperwork involved. So if you've got a good faith offer and you back it up and there aren't other issues, because I don't know, there are often dynamics in some of these communities where also people have been butting heads on other issues, like your hedges aren't cut close enough or this or that. If it's just a money thing, then I'm optimistic, but you should reach out to Ms. Webb. She's going to hold all the cards because she'll have this judgment. And so if she in the end says, Mr. Williams, that's just not going to work, she could always move forward with the judgment. But hopefully you're in a position to work something out with her. Okay. Mr. Denhart, anything else on behalf of your client?
No, Your Honor.
On an unrelated matter, I owe you and the pro se defendant a follow-up order. I know you sent something to Ms. Niles recently. I haven't had a chance to look at it, but I'm going to, in that order, direct you, if this isn't what you already did, to put together what the order would look like to get the LLC transferred back to your client. But also there's the issue of the loan, because if it's not in the LLC's name or your client's name, then the defendant is stuck with the loan, and that's certainly not how it should play out. And I just wasn't sure, the lender isn't going to be interested in having the loan shifted to someone who they might not have given a loan to in the first place. So hopefully you've been thinking about what the language is in a proposed order that would affect the transfer that I explained to you and to the defendant your client was entitled to.
Yes, Your Honor. I can affect the language in planning to sell the property and pay off any kind of loan on the house.
Okay.
In the order for you.
Okay, well, I'll reach out to you, and I'm just blanking on the name of the defendant, but that person, with my direction from the hearing we had. I hadn't forgotten about it. I just haven't gotten around to it yet.
Thank you, Your Honor.
You're welcome. Mr. Williams, anything else, I'm going to say on your behalf, since you can't represent Amerigo. Anything else?
No, I mean, I could reach out to her and see what.
Sounds good. So do you live at the Pine Tree Place and your business is on Cheshire Bridge, or you live on Cheshire Bridge and your business is at the condominium?
The business is at, the business is on Cheshire Bridge.
Okay, and then your home is in the condominium?
Yeah.
But it's just in the corporation's name?
Yes.
Okay, all good. All right, well, if you don't have anything else, Mr. Williams, Mr. Denhart is going to get that proposed order to me. I'll enter it, and in the meantime, you and Ms. Webb should start talking.
Yeah. Do I get a copy of that?
So have you been e-filing things? So when something is filed, you get notice?
Yes.
You will get a copy, because I will sign it and then it will be e-filed. And so you'll have a copy of that. It's going to be called a final order and judgment, something like that. And it's going to say, in effect, Pine Tree has won, and they have a judgment of a little more than $7,000, and the ability to foreclose on the property if that judgment's not paid. That's the way they can be sure to be paid, because if they sell it, I'll make up a price. They sell it for $350,000. They take their $7,000, the mortgage gets paid off, and then you get whatever is left over. It's like putting a lien on the property.
The property has no mortgage.
Well, then you would get everything but the 7,000. You'd get a whole lot of money if there's no mortgage. But it would be a forced sale of your home, and you don't want that. And that's why you and Ms. Webb should get together. But Pine Tree reached a point where they felt it was not productive to go around and around with you. They retained Mr. Denhart's firm, and Mr. Denhart did what he did. Okay?
Thank you.
All right, good luck with everything. Thank you, Mr. Denhart. You are good to go.
Thank you, Your Honor.
Next up is Durham Lakes Property Owners Association versus the Dunnings.
Good afternoon, Your Honor. Danielle Burnett on behalf of the plaintiff.
Hello, Ms. Burnett. How are you?
I'm doing well. How are you?
I'm well. I don't see any Dunnings on the call, and there's no one in here but Deputy Gordon. And he does not represent the Dunnings. So I think here we're just marching through the default, and you are seeking on behalf of Durham Lakes the unpaid assessments, the ability to foreclose on the property if they don't get paid, and then your reasonable attorney's fees. Is that a fair statement?
Yes, that's correct.
Okay, and I think, unlike the previous position, you've already provided a proposed order. And I want to make sure the numbers are still good by you. It's got total recovery of $4,556.70.
Yes, that's correct.
Excellent. So if I'll read through the whole order, make sure I'm all right with it, but assume I am, that dollar amount represents what you think is a current judgment.
Yes, I do.
Okay. There was a line item in there where it says default hearing, it lists today in the $350. That's additional attorney's fees that reflect the cost of you preparing for and being present for the default hearing?
Yes, that's correct.
Got it. Okay. Then I think I have what I need. Any questions or items from you?
No, Your Honor.
Do the Dunnings still occupy the property?
Yes, I believe so. I have not had contact with them, but I do believe they still live in the community.
Okay, well, hopefully this will get their attention.
Yeah.
But I will take care of reviewing the order, signing it, and then you can take it from there.
Thank you, Judge. I appreciate it.
All right, have a great weekend.
You too. Goodbye.
All right, last but not least is Crown Media Holdings versus City of Atlanta. Who do we have on for that?
Austin Atkinson on behalf of the city, Your Honor.
And Judge Clark Calhoun from Alston and Byrd on behalf of Crown Media.
All right, Mr. Calhoun and Mr. Atkinson. So here's where I understand we are with this case. It is kind of a cousin to Block versus City of Atlanta. Very different companies, but as I understood Crown Media wasn't mine, it was Judge McAfee's, but he learned that I was handling Block and that it presented a very similar legal issue that the city took up on appeal. And we all agreed, we meaning counsel for Crown and the city agreed, let's just put a stay on the Crown Media Holdings case so we can see if the Court of Appeals is going to say, Judge McBurney, you were right, or nope, you were wrong. And I lucked out and they affirmed me. And so we seem to now have binding precedent from the Court of Appeals that is going to change the way the city assesses some of its taxes. And as I'm recalling, it was the same dispute with Crown that it was with Block. I don't mean to force that model on this case, but that's why we had stated. So I'm going to start with you, Mr. Calhoun, but I'll certainly hear from Mr. Atkinson. Am I kind of right about that? And if so, what are we doing next with this case?
Yeah, thank you, Judge. Yes, we would agree with your characterization. We view the issue as identical to Block and controlled by Block. We made them an offer in the last few weeks to pay the tax in accordance with the Block decision. Not quite sure whether they're going to accept it, why they wouldn't accept it. We've told them if we need to come back to court, we're going to be moving for costs, and hoping they'll accept our offer, and we'll be have this case resolved.
Got it. Those won't be cheap costs, Mr. Atkinson. What's the city's perspective? And I appreciate you don't get to decide on your own. It has to be pushed up any number of chains. But Block says what it says. Where's the city going with the Crown Media case?
And Judge, if I could add one other thing, not to cut Mr. Atkinson off, the city pretty specifically kind of carved him out of our settlement exchanges. So I mean, he's aware that we've made an offer. He's aware of what the offer is, but they really, maybe to control their own costs or whatever it might be, they seem to want not to include him in those specific discussions. So just for Mr. Atkinson's purposes, wanted to let the court know that.
Well, that's awkward. Okay. Well, tell me what you do know and where you think your client is going, even though they keep you a little bit in the dark.
So I appreciate that, Mr. Calhoun. And I do think the city wants to resolve it. And I am not disputing that they have not, responded to the offer. I think the pressure of this hearing that I put on me that led to me put a little pressure on them to finally get some more discussions recently. I think we might be a little bit closer, or the city might be a little bit closer than Mr. Calhoun and I both probably thought before this hearing, but I did not know that until about 4 minutes before I logged on. So I haven't had a chance to talk to Mr. Calhoun about it, but I do think they want to resolve it.
Okay. What can I do to be most helpful? I will not drag you guys onto more hearings if progress is being made, but it's a case from 2023. It was understandably on hold for a while by mutual agreement because of the pendency of the Block appeal, but that opinion came back a while ago, and we need to make sure this keeps moving. So, Mr. Calhoun, what are you recommending? I can put this on another status calendar that requires both of you to be here. Virtually is fine. Or I'm happy to just stay out of the way. I'm kind of reluctant to just stay out of the way because that may make it move a little more slowly.
Yes, thank you, Judge. My sense is that the city moves fairly slowly, and I would appreciate having something on the calendar to keep them engaged in discussions. Back on a status calendar, late May or June would make sense to me, and hopefully sometime before that we'll be able to announce a resolution.
All right, I'm just looking at the docket.
And Your Honor, I would also prefer we get put on the calendar from my perspective.
Okay, good. So yeah, it was transferred in May of 24, and then I denied the motion to dismiss, denied the certificate of review, and then we've just been in that holding posture. So there's not really a scheduling order. And I guess that's the leverage I have, is that we'll do one more of these status calendars. But if it's another report of, well, the city's having these conversations of which Mr. Atkinson's not a part, then I'll probably need to say, great, let's start discovery. And then those will all be costs incurred by Crown Media that could fall on the city's head later on. And so maybe that would be a little additional pressure. So why don't we do what you're both saying, which is to put this on a status calendar. I'll get with Ms. Niles and we'll figure out if we have one of those in June. I don't think it makes sense to put it on 3 weeks from now, but I don't want to wait until the end of summer either. So I'll see if we've got one that's kind of in between distance from here and the end of the summer. And ideally at that point, we'll have an update from the city. Certainly, if something comes up before then where you all reach an agreement, subject only to the different votes that would have to happen with the city council or whatnot, you can let me know and then we can take it off a calendar. But short of that, I'll look to get this on a June-ish calendar. Does that work for you, Mr. Calhoun?
Yes, thank you, Judge.
Okay, Mr. Atkinson?
Sounds good. Thank you.
All right, Mr. Calhoun, anything else I should be doing or thinking about in connection with the case?
No, I mean, I guess I will just say for my part, so that Mr. Atkinson hears it, if we're still not getting anywhere and it's getting into late May, my client might just tell me, let's get a motion for summary judgment in there. They may not want to wait all summer. So
okay, and that's sort of the vibe I was trying to send as well, which is the city needs to decide, hey, we're up against the block opinion, and either that forces our hand and we need to sort it out, or I don't know what else they'd do, and that would be the motion for summary judgment. And they could respond to it and go from there. I think that's helpful feedback from your side, Mr. Calhoun. Mr. Atkinson, anything else from the city?
Not today, Your Honor.
Okay. Well, thank you, gentlemen, for dialing in. You guys have a good weekend, and we'll get this on a medium distance status calendar.